Good morning. This is the Energy and Carbon Management Commission. It is September 3rd. It is 9 a.m. We will start with a roll call.
Commissioner Ackerman,
Here.
Commissioner Cross,
Present.
Commissioner Mesner,
Here.
Commissioner Oath,
Here.
Commissioner Robbins.
Here.
Mr. Chair, you have five commissioners present.
Good morning. All right. Five is a quorum. We exist for purposes of a business agenda today. I have a few matters on the agenda. The first is commissioner comments. Does any commissioner have comments for the rest of us and/or our stakeholders? Commissioner Oath.
Thanks, Mr. Chair. I would like to provide an update on a meeting that I attended on the Commission's behalf, and I attended that meeting along with Deputy Director Mercer Gelman and our community relations team, where we met with the signatories of a letter that was sent to us on July 7th of this summer regarding community engagement and environmental justice. I believe our environmental justice liaisons are listening in on our meeting this morning, should you have any follow-up questions. And certainly I believe and hope a number of folks who attended that meeting are also online with us today. You might recall that kind of shortly after we received that letter at our July 9th meeting, we had heard a presentation from EJ liaison Jessica Chavez about the community engagement plan. And I had asked the community relations team to look into, how we could build upon that plan in light of the suggestions that were included in the letter that we received. And, I really want to give kudos to our team who I think went above and beyond that and really collaborated with the signatories to put together a meeting and an agenda for that meeting to have a really good discussion about the letter. I really felt like there was a good amount of collaboration on the agenda and format of the meeting, and was a really great example of kind of that two-way collaboration and communication. Um, Due to open meeting law requirements, which preclude having, more than one of us commissioners at such a meeting, that was why I attended as a representative of this commission. I'm honored to participate in that meeting on behalf of and as a representative of the commission. Though I did emphasize and will continue to acknowledge that I don't speak and cannot speak on behalf of the full commission and can only, participate and provide my thoughts and perspective as one commissioner. But I wanted to give an update and share my thoughts on what we discussed. I believe that it was a very productive and honest meeting. I think we shared some mutual goals, particularly and primarily. I wanted to participate as a commissioner to listen. The signatories expressed concerns in their letters and in the meeting, and this provided a forum for them to even further articulate those concerns. I shared with them that I really appreciate also that they are taking a very solutions-based approach to their letter, and have also really clearly outlined some actionable suggestions for us to discuss. And we really worked towards finding consensus where we can, and particularly on what are the concerns and acknowledging that they are concerns for us to work on addressing. We discussed a number of solutions that they had proposed, and the ways in which the emerging engagement plan from the Community Relations Unit also addresses those concerns. And then we began to identify some actionable next steps for our liaisons to pursue with continuous input and collaboration from the community groups as well as individuals who signed on to the letter and participated in this discussion. And we kind of broke the discussion up into four subject areas. So the first was related to commission engagement. And so we talked about ways to improve and foster further commissioner engagement and also strive toward more parity between contact between that the commission has with operators as well as with community groups. And so one particular item that we talked about was having commissioners participate on community impact tours, and agreed to have our community relations unit team really collaborate on and with the community members on setting those up. Really, as I said, I know I can't commit the full commission to anything, but I felt very confident based on our previous conversations, particularly at that July 9th meeting, that all of you would be interested in that as well. So there will be more to come in that regard. We also agreed to have the community relations team lead a community outreach meeting program for which the ECMC proactively hosts community meetings on assorted topics. So these are two really big tasks, but I think very doable. The community relations unit is going to take the lead in implementation with input from community leaders as we move forward. The second topic that we discussed was around education and training. The group asked the agency to create a community member designee program, something akin to the local government designee program. And so while we acknowledge that the logistics of that present some challenges, we agreed to explore some IT mechanisms that allow individuals to opt into notifications when changes occur to our database. Really, we agreed to the core concern, which is that community members who are seeking notifications about events occurring that impact their communities. And we want to reduce the burden that there is for folks at the way things currently are set up in our systems. Folks are having to proactively monitor our database. And so we want to look at ways that we may be able to provide some more proactive notifications to folks who opt into something. Certainly need to acknowledge and did acknowledge in the meeting as well that, of course, there are significant, ongoing IT priorities and constraints on staff time and resources. And so we will need to navigate those in line with this concern and this desire to improve in this area. Third, we discussed transparency and guidance for community members regarding our complex rules. We agreed that our data is transparent, but it can be at times difficult to understand or to navigate or access. And so agreed to several significant improvements in this area. One is we agreed to providing more accessible data on our new and improved website, which has been unveiled recently. So a couple of examples there is working towards plain language summaries for OGDP applications and just having a lot more plain language content produced by ECMC. We also agreed to publish a newsletter that will describe some of the data, particularly the COGIS and the daily activity dashboard data. And then while we have made really amazing improvements to the website, we can continue to further enhance that and continue to improve there. We also agreed to further discuss transparency and particularly to explore how to develop a list of the sources of data that our LAS team uses when they evaluate and validate the OGDPs. So we agreed to explore how those sources and how and which are publicly available. And so more to come there. And then finally, the fourth topic was around decision making and denial criteria. I would say here that there were maybe some initial impressions or concerns when the letter was received that this topic was related to attempting to get back into or relitigating some of the rules that we have considered and made decisions on. And I would say I think the meeting was a success in a number of ways. And one is that we really had an opportunity for getting some more clarification about what was really the desire and the goal here. And to get some additional context to these recommendations. We talked about how while there are no explicit denial criteria or guidance, the rules themselves really serve in that capacity. And anything that is not compliant with our rules is by definition a basis for denying an application that comes before us. So on this topic, I would say that we have not come to agreement on solutions, but certainly have agreed to continuing the conversation and understanding the concerns that underlie this. Thanks for giving me so much time. It was a really robust and productive 2 hours where we outlined really a lot of work ahead of us. Specifically, we as commissioners will be able to take some road trips this coming spring to get out in the community and see different areas of concern in the state. Again, really want to thank the organizations and the individuals who attended this and for their collaboration and the solutions-oriented approach. And last, I would like to thank our community relations unit team. We have identified a number of next steps and topics where additional meetings and discussion is going to be beneficial. We have committed to a lot of next steps, and that the team's committed to all of them and excited about all of them. But I do want to, just note that these are things that are not that don't reflect the entire breadth of the new programming that this team is implementing, and that these solutions that we are discussing are things that would, supplement and be additional and enhancing to a lot of the other rule-based duties that this team has taken on. For example, the complaints process and operator compliance with community engagement expectations pursuant to our new cumulative impacts rules. I say that to remind ourselves that there's a lot of good work already being done that sets a foundation from which we can expand our community engagement best practices. Many of the solutions and tactics we discuss require time and resources from our CRU team, and I, as a commissioner, want to defer to that team and leadership to prioritize and sequence them appropriately within their workload, and recognizing and knowing that it is on top of some other core critical duties that the team is committed to. Again, thanks for indulging a significant amount of time, but I really did want to share some details about our discussion and thank all of the folks who are participating, and just note that there's a lot more dialogue to come.
Thank you, Commissioner Oath, for the update. Couple of just thoughts after listening to the presentation. One, I, as one commissioner, am happy that you were able to have a discussion that this is not a tool for relitigating rules or reopening up things, because we're working hard on a lot of things that we've just recently passed. And so I think that is a message that I would echo. The second piece is where folks are wondering about, you mentioned denial criteria. I just would point you to the slide deck that our team put together for the legislature last year. It's about 60 some odd slides, and it refocuses the discussion around approval denial to what sorts of applications are we receiving? What sorts of applications are we not receiving? And really focuses in on the substance of the rule deck that now doesn't really allow for applications that are not going to be, looked upon favorably based upon what we've got in hand. The slide deck did, I think, a good job of explaining to legislators sort of the really 180-degree change from pre-181 to now. And so at some point that could be a really good tool for you and or our community relations team to go back to. We put it together purposefully so that it could be reutilized for different groups. And I think this group might benefit from listening in on that. So that would be sort of the second point. The third point, love the idea of trying to figure out some sort of community engagement tool relevant to the local government designee tool. The only caution that I sort of come to mind right off the head is local governments are defined. We know who they are. We know this is a city. We know this is a county. Communities is not as defined and can become, a community of 4 or a community of, 500. And so just sort of thinking about that, I think would be important as we develop up some additional transparency around community engagement, which again, I applaud. So just some initial thoughts off the head as I was listening in on some really great work that was being done. Others with comments? All right, go forth and prosper. Commissioner Messner, you're recognized as well.
Thanks, Mr. Chair. Commissioner Oath, really appreciate your work on that. That's exciting. And I really do appreciate the attention to detail and the next steps that you're contemplating there. So thanks for that. I do have just a quick update on the recommendations that ECMC asked the Colorado Produced Water Consortium to provide at the conclusion of our produced water rulemaking earlier this year. I'm happy to announce that the Colorado Produced Water Consortium has finalized some recommendations. Those recommendations will be sent to Director Murphy at the end of this year. They're consensus recommendations. It's a consensus recommendation based on what the consortium was asked to do by ECMC, which is an exploration of alternatives to a complete prohibition of centralized produced water treatment facilities in disproportionately impacted communities, resulting in recommendations for enhanced protections in disproportionately impacted communities. So we had a meeting on Friday that concluded the recommendations, and their Director Dalton will be incorporating some final comments from that meeting into those recommendations, and by end of day Thursday should have it to Director Murphy. It will also be published on the Colorado Produced Water Consortium website for folks to be able to see it. So that's all.
Summarizing, that's all. It doesn't do merit to the great work that you've been leading there, Commissioner Messner. I know that there's a great group of Colorado constituents that are involved in all of this. These are really important topics, and they're not easy. So thanks for landing that ship. We'll all look forward to reading the report once it comes out here in the next week or so. Others with commissioner comments? All right, seeing none. Really appreciate the reports back. Shows the work that we're doing behind the scenes. We have a consent agenda. Does anyone have questions on consent? Seeing none, do we have a motion to approve consent?
So moved. Second.
Motion and a second. Further discussion? Seeing none, all those in favor signify by saying aye. Aye.
Aye.
Any opposed? That motion carries. All right, we now have an update from our staff. Director Murphy is recognized. Good morning.
Good morning, Chair. Good morning, Commissioners, and good morning to the stakeholders who are listening into this morning's presentation. I will acknowledge that I-70 had a huge accident, so I have one of my favorite helpers with me. If you hear little squeaks, my daughter's right below my feet. But today I wanted to provide a follow-up to a presentation in July from Arthur Kupsel, our environmental data supervisor, who gave an update about operator compliance with House Bill 22-1348, oversight of chemicals used in oil and gas. His update was comprehensive, detailed, and provided a significant amount of information. But we also committed to returning to you at a public hearing because this conversation is continuing to evolve in real time and it's complex. So we wanted to be able to also provide an update. So I'm pleased to share with you that the positive compliance trend has continued. And as always, regulatory compliance is our goal and expectation. So as of yesterday, September 2nd, 2025, which is the most recent available data that Arthur has reviewed, ECMC is now seeing 97% compliance with the reporting required by the Act as implemented by our rules. That number reflects the percentage of operators who have complied with the requirements to submit Form 46s, which is the form we use to capture the data pertaining to House Bill 22-1348 around chemicals used in downhole production or downhole production operations. So again, that's 97% compliance as of yesterday with House Bill 22-1348's chemical disclosure requirements. This is a significant increase over the past few months. And so to summarize Arthur's presentation from July, which was incredibly detailed as we expect given our regulatory requirements, and so this is the recap. The PSR, or Physicians for Social Responsibility report, found that 1,114 wells reported to Frac Focus between July 31st, 2023 and May 1st, 2025. Of those wells, only 439 or 39% had a Form 46 filed for it, or the chemical disclosure form. We assessed our database between May 1st and July 7th, and between May 1st and July 7th, compliance increased from the 39% found by Physicians for Social Responsibility to 89% based on the wells that were reported to Frac Focus as having the Form 46 reported for chemical disclosure. And again, I'm pleased to reiterate between July 7th and yesterday that compliance has continued to increase, and we are looking at roughly 97% compliance at this point in time. So we will continue our work to hold operators accountable to these rules so that this positive trend maintains. Our ultimate goal is always 100%. And again, in the event of noncompliance, we have the authority to take enforcement action, which we have done to date. So as you well know, our rules reflect the most protective regulations in the country. The Commission has a robust enforcement program to ensure operator compliance with the rules, and our staff is routinely monitoring operator compliance with rules, including the rules implementing House Bill 22-1348, and we hold operators accountable for noncompliance. When an operator is alleged to be noncompliant with ECMC regulations, whether it's those relating to 1348 or other regulatory requirements, we have the authority to investigate, issue warning letters, initiate enforcement, and those enforcement actions may result in the Commission imposing penalties through orders by the Commission. And so, as a quick refresh again to our conversation in mid-July, at that point in time, ECMC had issued 12 warning letters for noncompliance and 4 NOAVs with Rule 437, which is related but not an implementing rule for House Bill 22-1348. Regarding the warning letters for noncompliance with the rules implementing House Bill 22-1348, I'm pleased to report that of the 12, 7 came into compliance in the past 2 months, and those warning letters are closed. One operator was not out of compliance to begin with because the identified well was never drilled, so that warning letter has also been closed. So if you're keeping track, that's 8 out of the 12, and the remaining 4 warning letters are in. Our staff is in regular communication with the operators, and the operators are actively working with the chemical manufacturers to obtain compliance. If these operators remain non-compliant for an extended amount of time, staff may issue a notice of alleged violation. And at that point in time, that would enter the process during which the Commission would have the authority to impose fines as part of that enforcement process. For the NOAVs that I referenced earlier related to Rule 437, 3 have been closed and 1 remains open. The 3 NOAVs were closed because a chemical was incorrectly reported as an ingredient by the chemical provider. And the 1 NOAV remains open at this time and will be resolved through the enforcement process. As you would expect, staff continues to monitor operator compliance with House Bill 22-1348 statewide. And as you know, evaluating compliance with this reporting requirement is and will continue to be real time and will change with every review conducted by staff, much like ECMC's other compliance reviews. Operators have roughly 120 days to submit reports after hydraulic fracturing begins, so there will always be a lag in compliance audits from the date of hydraulic fracturing to the date of submission to us. Through staff's routine review of submittals, including those related to House Bill 22-1348, we have identified an operator who has become out of compliance in just the past month. We are in communication with the operator, and we may issue a warning letter if needed. I want to recognize that we did receive a letter from Physicians for Social Responsibility on August 27th, and the letter addressed the positive trend with compliance while also citing some additional concerns and questions around reporting and enforcement. I would like to acknowledge that we are actively monitoring chemical disclosures, as is reflective in these comments. And we're improving how we are doing that compliance review and building more effective tools for auditing that data. Again, regulatory compliance over the long term remains our priority and expectation with the rules implementing House Bill 22-1348 and all other rules that this commission has adopted. And at this point in time, I would like to conclude my remarks and I would welcome your questions. And we do not intend to continue with updates on this topic unless you would like it. Sorry. And I certainly want to acknowledge the hard work that Arthur and others have put into the monitoring compliance with this. So with that, I actually will conclude my remarks. Thank you, Chair.
Thank you, Director Murphy, for the update. Really appreciate the good work and response to this matter. I think it shows the seriousness within which the ECMC takes this. Do folks have questions? All right, I'm not seeing questions. Great update. Thank you very much.
Thank you.
Say hi to Murphy. All right. With that, let's tee up the next docket and take 5 minutes to get the attorneys up. That's the docket ending in 034. It is 9:26. Let's return at 9:31.
As a petitioner contesting Extraction's pooling application. As we're sitting here today, 100% of Anadarko Land Corp's interest is still listed on Extraction's Rule 505 sworn testimony as an unleased mineral owner to be force pooled and subject to cost recovery penalties. Despite the fact that Extraction knows that Anadarko is no longer the party that owns the minerals and that interest has been split between two different parties, one of which they're treating as consenting and one of which they're treating as non-consenting. The latter of which is what's at issue today, and I'll refer to it as the Elk Range interest. And as you listen to the arguments today, I'd like you to contemplate the intent of the force pooling statutes and the reasons for applying non-consent penalties. There may be a situation where a mineral owner, work interest owner, is unwilling or cannot pay its proportionate share of costs, or a mineral owner did not want to enter into a lease. So it makes sense for an operator to obtain cost recovery penalties under the Energy and Carbon Management Act for carrying that risk until costs are recovered. That's not the case here. If you take Extraction's argument at face value, they only had to technically provide notice of the pooling application and identify the list of owners at the time of the filing of the application on March 6th. It was not required to update the owners on Exhibit A that are subject to cost recovery penalties. The no interested party has any transparency about whether their interest is subject to those cost recovery penalties, and your order does not, as required by CRS 3460-116, determine the interests of each owner in a unit to be force pooled. In addition, and again, taking Extraction's technical argument that only had to provide notice of the pooling application and elections to participate or lease to Elk Range's predecessor in interest, Anadarko Land, Extraction would have had to apply non-consent penalties to their own lease if Elk Range decided to lease with them in May 2025. After all consenting parties are entitled to share in those penalties, but Extraction was asking Elk Range at least to join their working interest without applying those penalties. They're trying to increase their working interest percentage by only allowing Elk Range to enter an oil and gas lease with Extraction. This is a commission issue and goes to the heart of whether Extraction provided every owner a good faith offer to lease or participate under CRS 3460-116 and Rule 506. By entering into a lease in Extraction's place, Incline expect Extraction to operate in good faith and acknowledge Elk Range's desire to participate, even though the land testimony showed Anadarko's entire interest as an unleased mineral owner was subject to cost recovery penalties, which was filed on May 19, 2025. But Extraction did not do so here in its filings with the Commission. Incline was justified in filing a late petition, and when it realized it would recognize only a portion of the Anadarko mineral interest as consenting. The Commission does not have authority under CRS 3460-116 to subject an unleased mineral owner to cost recovery penalties when that owner did not have notice of the pooling application, did not have a good faith offer to lease or participate. Under the circumstances, Incline should be granted leave to file late petition as a current lessee of the Elk Range interest and petition against extractions pooling application. I'm going to ask Cole Kelly to share some demonstrative slides, everything that we found in their petition, to kind of just walk through the history of things here. If I could be given that function.
You should have it.
I just gave them that permission. You should have it now.
As we go through the following slides, you'll see that the good cause does exist to allow Incline to file a late petition, based on the fact that Extraction 1 did not provide notice of the pooling application to Elk Range, GSM, or Incline. 2, Extraction extended the deadline to respond to election letters to May 21st, 2025, which was over 2.5 weeks after the protest deadline. And Extraction did not respond to Incline's repeated requests in June 2025 to clarify that would not be forced pooled, even though Extractions lists Anadarko land as an unleased mineral owner in land testimony and recommended orders. Cole, if you could go to slide 2 for me. This slide shows a land testimony of Extraction sworn to under oath by Leslie Mann on May 19, 2025, stating the exhibit to that land testimony is a list of owners of oil and gas interests in the tracts to be pooled. It shows Anadarko Land Corp as an unleased owner, subject to the penalties provided under 3460-116. It does not list Incline, Elk Range, or Golden Spike, even though they had noticed at least a month prior that Anadarko Land Corp no longer owned those interests. The same goes for all of Extraction's list of interested parties and mailings related to this docket. None of them list Incline, Elk Range, or Golden Spike. You go to slide 3 for me. Anadarko Land owned interests on March 6, 2025, when the application was filed. It sold its mineral interest to Elk Range shortly thereafter on March 21st, 2025, who has split that interest up into Golden Spike minerals, and then it kept that interest in 3 related entities. Golden Spike leased with Incline, which interest is being treated as consenting by Extraction, at least pursuant to an email agreement, because it's not characterized as consenting on Extraction's land testimony, which shows Incline's confusion and the late filing of this petition. Elk Range also entered in a lease with Incline, but Extraction is treating the interest as non-consenting. Extraction has not updated the testimony, just lists Anadarko as an unleased mineral owner to be forced pooled in its entirety. You go to the next slide. This is a timeline of key events related to the petition, deadlines, and the May 19th Rule 505 testimony, which we'll look at the emails in upcoming slides. But to set the stage, Elk Range informed Extraction on April 9th, 2025 of the transfer and asked for extension to elect to participate. On the same day, Extraction, through Ms. Mann, who also submitted Extraction's Rule 505 testimony on May 19th, stated that she would send Elk Creek updated elections and grant extension from April 14th to April 21st for Elk Range to respond. Thereafter, Extraction asked for more time to get an offer to lease together, and on April 17th, 2025, asked for an extension of the proposal deadline until May 21st, well beyond the petition deadline of May 2nd. The petition deadline passes on May 2nd. On May 6th, well within the extension granted by Extraction, Elk Range still is an unleased mineral owner, informs Extraction is going to another direction with the lease with them, and again requests for updated elections that Leslie Mann committed to send in April. They also informed Ms. Mann and Extraction of their plan to consent. Extraction withdraws the offer on May 7th and says it only would have granted the extension if Elk Range leased with them. Since that time, Extraction did not file updated land testimony and ignored Incline's request in June after it took a lease with Elk Range to get a determination of how it plans to treat the Anadarko land interest listed on the land testimony. This continued until June 30th, 2025, just before the hearing date, when Extraction informed Incline it was treating the Elk Range portion as non-consenting, and Incline filed this petition the next day. You go to the next slide. Exhibit C in Incline's petition, just kind of direct you to where it is in the record, is an April 9th, 2025 email from Leslie Mann to Elk Range. It shows Ms. Mann's response to Elk Range's request for transfer and to update elections. She specifically stated, "We will start working on updating the well proposals to reflect the new ownership you provided below." Next slide. On April 17th, 2025, if we start at the bottom of the email, Ms. Mann reaches out to Elk Range and says, we will extend the proposal deadline to 5/21, which is past the petition deadline of 5/2, to take the pressure off given the holiday. Elk Range still expected the proposals and offer to lease as stated would occur in the April 9th, 2025 email. Elk Range agrees to extend to May 21st, way past the petition deadline. Next slide. On May 6th, 2025, again, while within the May 21st extension and after extraction only sent the offer to lease, Elk Range responded that it would be holding off on leasing and again asks for extraction to proceed with preparing the election packets, stating they would likely be consenting to participate. Extraction never sent update elections, despite the representations in early April that those would be provided. Next slide. Finally, on May 7th, 2025, Extraction responded that the extension had only been offered if Elk Range had decided to lease with them, which is not good faith or was required in good faith to provide unleased owners like Elk Range. Next slide. You can see that Incline returned elections for the separate interest for Golden Spike at the bottom of the email on May 27th, 2025, which we talked about earlier is the portion of Anadarko's land's interest that Extraction is apparently recognizing as consenting. On June 10th, 2025, Incline sends 3 oil and gas leases that entered into with Elk Range and states it could just bind Incline to the previous elections. Incline also acquires at this time why the land testimony still lists Anadarko land as a non-consenting mineral owner and that he's assuming it's an outdated reference. Next slide. You can see that Incline continued to attempt to reach out to Extraction for clarification if it was treating as non-consent throughout June 2025. It did not get a response until June 30th, 2025, and then Incline filed the petition the next day. CRS 3460-116-7B requires that a pooling order determine the interests of each owner of the unit. It also requires that a pooling order must be made after notice and a hearing and must be upon terms and conditions that are just and reasonable that afford each interest in the drilling unit the opportunity to recover or receive without unnecessary expense. It's just an equitable share. CRS 34-116 has heightened requirements to force pool unleased mineral owners like Anadarko Land and Elk Range, which was the whole purpose of the revisions to the statute following Senate Bill 24-185. Extraction's argument is that Elk Range took the interest on the deadlines of Anadarko and that technically did everything pursuant to commission rules by giving 60 days. But those rules also require that Extraction operate in good faith under the statute in Rule 506B in providing lease offers and offers to participate. As evidenced by slides we went through, Extraction's actions are not in good faith in its treatment of an interested party in this proceeding. Moreover, Rule 501B explicitly states the Commission shall prevent, limit, prohibit misrepresentations in pleadings or testimony or other inappropriate, outrageous conduct as deemed by the Commission to be an abuse of process. To say the least, Extraction's land testimony on Rule 405, filed on May 19, 2025, creates a lack of transparency and puts all the power in the hands of the operator to deem an interest as consenting as it sees fit. I guess, of course, if an unleased mineral owner decides to lease with Extraction, there would be no issue with consenting versus non-consenting in this scenario. Based on the communications between the parties, the extension election deadline past the May 2nd petition deadline and the lack of response to Incline's request for clarification, good cause exists to allow Incline leave to accept the petition and protest the pooling application of Extraction. Thanks.
All right. Thank you very much. Commissioners will probably proceed just directly to oral argument from Ms. Wozlinski at this time.
Thank you, Chair, and thank you, Commissioners, for your time today. Incline's exception raises one primary question for the Commission to determine today: whether there's good cause to allow Incline to file a late petition to Extraction's pooling application, which has been recommended for approval by the hearing officer. As the hearing officer properly determined in her order denying Incline's motion for leave, Incline does not meet its burden to demonstrate good cause to allow a late filed petition, and therefore Extraction respectfully requests that you uphold the hearing officer's order denying Incline's motion and approve Extraction's pooling application today. The record in this matter is clear, and in fact, it is undisputed that Incline's predecessor in title was given timely well proposals, a lease offer, and notice of the application in accordance with all applicable ECMC rules and provisions of the Act. Incline attempts to argue that Extraction made certain representations regarding well proposals during the election period for the subject wells as the basis for its request to file a late petition. However, such allegations are without support and fail to demonstrate any reason to allow Incline's late petition or to deny Extraction's pooling application. Further, the record is abundantly clear that Extraction complied with all aspects of ECMC rules and the Act with respect to the subject pooling. The processes and procedures surrounding pooling and petitions are very clear and straightforward, and it is important to walk through these under the undisputed facts in this matter. Starting with the election process, Rule 506 and the pooling statute require that well proposals and lease offers contain a minimum 60-day election period and be tendered with or prior to filing a pooling application. On February 12th of 2025, Extraction tendered a lease offer and well proposals to unleased owners and working interest owners within the unit based on record title at that time. Anadarko Land Corp. Was one of the undisputed record title owners of unleased mineral interests within the land subject to the pooling application and received the well proposals and lease offer around February 13th of 2025. On March 6th of 2025, Extraction filed the subject application to pool all interests in an approximate 1,360-acre drilling and spacing unit and to apply cost recovery penalties to unleased and non-consenting working interest owners for the development of 18 proposed T-bone wells located in Weld County. Extraction's application was filed with an interested parties list that included owners in record title as of the time of filing the application, in addition to sworn testimony with the well plats for the wells, a representative election letter, a representative lease offer, and the AFEs for the wells. On March 21st of 2025, Elk Range acquired the mineral interests of Anadarko Land Corp. In the subject drilling and spacing unit. Incline does not dispute this fact. On March 31st of 2025, Anadarko Land Corp. Provided the well proposals and lease offer to a representative of Elk Range as the new record title owner of these interests. I want to note here that the well proposals and lease offer were provided by Anadarko to Elk Range during the 60-day election period, and again, Incline does not dispute this fact. On April 9th of 2025, also within the 60-day election period, Elk Range requested an extension of the 60-day election period, and Extraction agreed to extend the election period by 7 days to April 21st, 2025. Again, Incline does not dispute this fact. On or around April 10th of 2025, Extraction and Elk Range commenced good faith lease negotiations, during which time Extraction extended the election period a second time for an additional 30 days to May 21st of 2025. Again, Incline does not dispute this fact. On April 24th of 2025, Extraction accepted Elk Range's lease terms and sent Elk Range an oil and gas lease with proposed edits. While we recognize that your jurisdiction does not include the adjudication of contractual disputes, I do want to make it clear that Extraction was working in good faith with Elk Range on a negotiated oil and gas lease, as evidenced by the voluntary extensions of the election period beyond the mandated minimum 60 days. In early May of 2025, Elk Range paused lease negotiations with Extraction. On May 21st of 2025, which was the expiration date of the extended election period, Elk Range had not accepted a lease offer or returned an election to participate in the wells. Pursuant to Rule 506C and the pooling statute, Extraction was authorized to apply cost recovery penalties to the interest of Elk Range as of May 21st, 2025, when Elk Range failed to return an election during the second extended election period. On June 10th of 2025, Elk Range entered into an oil and gas lease with Incline, and Incline informed Extraction of its status as a leasehold owner within the unit. Incline does not dispute the fact that it came into title in these lands over 3 months after the pooling application was filed, 58 days after the original 60-day election period expired, and 20 days after the extended election period expired. The facts here are very simple. Neither Anadarko Land Corp., Elk Range, or Incline elected to participate or lease in the T-Bone wells during the election period, as extended by courtesy of extraction, and therefore extraction may apply cost recovery penalties to this interest via order of the Commission. This authority is clearly delineated under Rule 506D and Section 3460, 116, subsection 6 and 7 of the pooling statute. Turning to the notice petition deadline, extraction mailed the notice of hearing for this application to all interested parties, including Anadarko Land Corp., on April 1st of 2025. The notice included a petition deadline of May 2nd, 2025. This date aligns with Rule 507D, which requires that a petition be filed with the Commission and served on the applicant's counsel at least 30 days before the noticed hearing date. No petitions to the application were filed by any interested party by May 2nd of 2025. In order to grant Incline's exception and allow a late petition, you must have good cause to do so under Rule 507E, which states that the filing deadline for the filing of petitions may be extended for good cause upon any continuance of a hearing. As the hearing officer cited in her order denying Incline's motion for leave, good cause exists when there are unforeseen and exceptional circumstances requiring a continuance. As also noted by the hearing officer in her order denying Incline's motion for leave, extraction has certified compliance with Commission requirements to provide notice to Anadarko Land Corp., and Incline does not contend that notice to Anadarko was incomplete or non-compliant. Further, documents attached to Incline's motion indicate that at least as of March 31st of 2025, the same date that the Commission Secretary issued the notice of hearing in this matter, Elk Range received from Anadarko actual notice of extraction's offer to lease and participate in the proposed T-Bone wells. These facts demonstrate that notice provided to Anadarko Land Corp. Is properly imputed to Elk Range and thus to Incline as Elk Range's lessee. The 2021 Colorado Court of Appeals case of Freedom Holding Co. v. Ritchie holds that a predecessor mineral interest owner's knowledge is imputed to successors in interest. It is therefore reasonable to conclude that Incline was expected to determine, as at least the interests of Elk Range in June of 2025, that Elk Range's interests were subject to a pending pooling application noticed for a July 2nd, 2025 hearing, that the minimum 60-day election period to lease or participate in the proposed wells had expired, and that the May 2nd, 2025 petition deadline had also passed. Instead of accepting these facts, Incline attempts to create an argument based on alleged misrepresentations in contractual negotiations that are not only patently false, but fall well outside of the jurisdiction of this Commission. Should you grant Incline's exception and accept its late petition, you would be forced to step outside of the four corners of ECMC rules and the Pooling Act and review irrelevant correspondence between the parties and somehow conclude that extraction should reopen the election period and allow Incline to make an election months after the pooling application was properly noticed and the election period had expired. This is not only improper and contrary to the clear mandates of your rules and applicable law, but would render the 60-day election period codified in both the Pooling Act and Rule 506 meaningless. The last point I'd like to address is Incline's argument that extraction improperly lists Anadarko Land Corp. In its sworn testimony in this matter as an unleased owner subject to cost recovery. Nothing in the rules or the Act requires a pooling applicant to update title after filing a pooling application and after the election period has expired to account for changes in title or lease status and reflect these in updated sworn testimony. One of the major tenets of pooling is to provide both the operator and the mineral owners with certainty as to the consent or non-consent status of the mineral interests prior to the entrance of a pooling order. This is why elections must be tendered at least 90 days before the pooling hearing date, with a minimum 60-day election period per Rule 506A. This process results in a clear list of non-consenting and unleased interests who received an offer to lease or participate at least 90 days prior to the pooling hearing, which are then reflected in the final order of the Commission. If you accept Incline's argument as true, then an operator would be forced to constantly run title updates after filing an application and up to the pooling hearing to account for any transfer of mineral interests or new leases taken. Would these new mineral owners then be entitled to a new offer to lease or participate? This would result in a never-ending election process that provides no certainty at all to mineral owners or operators in the context of pooling, and renders the 60-day election period in both Rule 506 and the pooling statute meaningless. This is simply not how the pooling law works and would lead to unreasonable and untenable results. Anadarko Land Corp. Was the record title owner at the time the application was filed, was the proper recipient of the well proposals and lease offers prior to the application being filed, was the proper recipient of the notice of hearing mailing in April of 2025, and is therefore properly listed as an unleased owner in the recommended pooling order. Both Elk Range and Incline took this interest subject to Anadarko's designation as an unleased owner. Again, this interest was unleased when the application was filed and when the election period expired. The interest was leased to Incline 58 days after the original 60-day election period expired and 20 days after the extended election period expired. The July 16, 2025 supplemental sworn testimony submitted by May 16th, in this matter, makes it clear that any record title successors to the interested parties represented on the interested parties list will be subject to the consenting or non-consenting status of their predecessors in title. And specifically with respect to the interest of Anadarko Land Corp., the successor to this interest that did not elect to lease or participate within the election period will be subject to the non-consent penalties provided for under Section 3460, 116, subsection 7 of the Act. For these reasons, the recommended pooling order before you today properly lists Anadarko Land Corp. As an unleased interest subject to cost recovery penalties, which will be applied to Incline's interest as the successor. For the reasons I summarized today, as well as the substantial record in this matter, the hearing officer properly found that Incline's motion does not demonstrate unforeseen or exceptional circumstances that justify reopening the petition period. As I mentioned, the portfolio for this matter includes a recommended order to approve the application dated July 23rd of 2025, and you are able to act on this recommended order today. Extraction again respectfully requests that you uphold the hearing officer's order denying Incline's motion for leave, deny Incline's exception to the hearing officer's recommended order, and approve Extraction's pooling application today. Thank you for your time.
All right. We have heard oral argument from both sides. At this time, commissioners, we will have an opportunity for questions, although there's not a requirement for questions, but if anybody desires some additional clarification, we can do that. Otherwise, we would move to deliberations. Questions from any commissioner? Commissioner Cross?
Thank you, Chair. And for Incline, could you provide a little bit more detail on when you began negotiating with Elk Range about these mineral interests?
Yeah, so Incline began negotiating with Elk Range around the May 6th, 7th time period and entered a lease in June. I think on May, as far as Incline and the Golden Spike interest, remember Anadarko was split into two interests, and there's Elk Range and Golden Spike who also leased with Incline. Incline responded to an email and said, we consent to these elections. Elections weren't sent to Incline for the Golden Spike interest till well after the petition deadline. They signed them, returned them. On April 9th, Ms. Mann states she's going to give an extension of the proposed deadline eventually to 5/21, and that she was going to send new elections with the lease. And on May 6th, within May 21st, Elk Range clearly said they intend to not lease with them, but they intend to participate, or at least in likelihood they would participate if being technical. So that Incline fully expected them to operate in good faith and send those updated elections. What happened afterwards is no one heard from Extraction until June 30th, despite repeated requests. So I don't dispute the lease was June 10th, but negotiations were ongoing. I think this happens often before pooling applications, and tangentially to your question, if you take Extraction's argument at face value, they would have to treat their own lease with Elk Range as non-consenting and allow every consenting party the right to participate in those costs. They were going to do that. They were going to lease with them and put a part of those working interests as consenting. So that, I guess that's the response to that.
Okay, and you said this is something that happens quite often, but I think something that we also see that happens quite often is petitions get filed almost out of an abundance of caution to try and preserve rights. So do you have any idea why that wasn't done, even though that happens often as well?
Yeah, because for the Golden Spike portion, we were told we were able to consent. For the Elk Range portion, the lease on June 10th, we reached out on June 10th, June 27th, June 30th. I believe Blake Beavers, who you saw in those emails, called as well and had no response. We just expected them to operate with, in good faith as defined by the commission rules, as consistent with the practices of the industry, essentially. We expected them to do so.
Okay. Thank you. Those are my only questions.
Other questions for counsel of record? All right, counsel, thank you very much for the oral argument. We will now turn this back to commission for deliberations. Commissioner Cross?
Thank you, Chair. And I'll be honest, I'll be somewhat brief with this. I don't want to get too much into the representations made, the arguments back and forth. I think the biggest thing for me is at bottom, I don't think that there's good cause to grant the exception here. I think one of the things that sticks out to me throughout this entire process is that these are sophisticated parties. This is not, a single farmer with some mineral interest trying to figure out what's going on here. These are parties that engage in these kind of negotiations, engage in these transfers quite often. And as was shown by Extraction, there is the freedom holding case that does talk about knowledge being imputed here. And I think the basis of that is the fact that this pooling application was filed, the fact that this was on the books for quite a while is known to everybody. These are parties that, as I said in my questions, a lot of times you'll see petitions get filed just to preserve the rights, the ability to bring up a challenge later if necessary. It doesn't mean that the petition can't be dropped later on. And I think numerous parties had the opportunity to do so throughout this. I think what really ends up happening here is there's continued negotiations, there's some extensions granted, we believe this was going to happen, but believing that something's going to happen and additional extensions and additional things being sent out is not an unforeseen circumstance. It's not an exceptional circumstance that is going, in my mind, is something that should extend this deadline to file the petition. And ultimately, I think that that's the question that is faced here is, should there be an exception filed saying you should be granted leave to file your petition? And I don't think that there is any kind of exceptional circumstance that would say, yes, they should be given additional time. These, again, are sophisticated parties. This has been going on for quite a while. I know Ms. Wozlinki at one point in time said this would end up with a never-ending election process as you continue to update. And I do think that that's a valid point, but at the same time, I think there's also an importance of putting the onus on, especially when they're sophisticated parties, putting an onus on the potential lessees, the potential transferees here. As they're dealing with these negotiations with Elk Range, they knew that the pooling application was out there, or they should have known the pooling application was out there. As they're making this negotiation and going through the terms of the contracts and the transfer, that's something that they should be taking into account as they're negotiating the terms of, hey, we may be past the petition here, or hey, we're willing to do this, but only if you get a petition filed in time. So we have the ability to do something here instead of just continuing to rely on additional extensions. Well, we're still trying to do this. Maybe we can update this. And even the intention of will probably consent to this. These are things that sophisticated parties should be able to work out in negotiation, should be aware of, and should try and make sure that they preserve their rights. So again, I think really when we look at the simple issue here with respect to the exception, should there be additional time granted to file the petition, I don't see any good cause to grant that additional time.
Thank you, Commissioner Cross, for leading off on deliberations. I'm in agreement with you. Further deliberations from commissioners? Commissioner Ackerman?
I'm also in agreement. Just a couple of other points. I do think that a double extension does demonstrate a degree of good faith throughout the process, and want to note that we've heard arguments from both parties today, but as has been mentioned by both parties, our staff's recommendation also is to move forward and to not extend and allow a petition as well. I think that's the right determination given the circumstances, and I'm in support of it.
Further deliberative thoughts? All right, seeing no further deliberative thoughts, AAG Davenport, maybe if you could visualize yourself. I believe the proper motion that at least three of us have indicated is to uphold the hearing officer's order. Is that right?
Yes, that's correct.
All right, I would so move to uphold the hearing officer's order.
That's second.
We have a motion and a second. Do we have further discussion? Just a second, Ms. Wazelinski. I'm taking this one step at a time. All right, seeing no further discussion, all those in favor signify by saying aye.
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 Any opposed? All right, the hearing officer's order is upheld. Now, commissioners, I believe we have the opportunity to either move to approve the pooling order that is reflected in the recommended order in the docket, or we could not do that today and put it on the consent agenda for next week. I'm really agnostic on that point. Does anybody have thoughts? And AG Davenport, did I get our procedural options correct?
Yes, I think those are your options.
All right, seeing no real thoughts, I would move to approve the pooling order as reflected in the recommended order.
Second.
Motion and a second. Is there further discussion? All those in favor signify by saying aye.
Aye.
Any opposed? That motion carries. Thank you very much to Council of Record for their presentations today. This matter is now resolved.
Thank
All
you.
right, let's take 5 more minutes. Let's get docket that ends in 228 up. I do not believe we're going to hear arguments from council on that. In fact, commissioners, if you're comfortable, let's just take it up and then we can take a break before the OGDP. Does that sound okay to everybody? All right. All right. I've got some thoughts on this. If commissioners are okay, I'll lead off. We have before us deliberation of Frederick and DeCono's motion for post-trial relief. As I noted, this is not scheduled for oral argument today. The briefing was clear and well done. And I, as one commissioner, am prepared to make a decision without argument. If any commissioner desires that we need argument, let me know right now. Otherwise, I'm going to go into some deliberative thoughts. All right, seeing no reflect for oral argument. As I see it, there are 2 issues raised by DeCono and Frederick's motion for post-trial relief and subsequent pleadings filed by the local governments and KPK. First, whether the local government's motion is procedurally unripe, and second, whether the commissioners erred as a matter of law in regard to its findings and conclusions during deliberations on June 26 of 2025. And the local governments would argue that the commission must redeliberate and reach a different conclusion. I, as one commissioner, conclude that KPK is correct that the local government's motion was unripe and therefore would support a motion to deny the local government's motion on the grounds that it was premature. That does not mean that the local governments do not have an opportunity to file their motion at the right time. If my commissioners agree, there would be no reason to reach the merits of the local government's arguments at this time. Background. First, I would like to note that to my knowledge, this is an issue of first impression for the commission. While the commission has decided upon motions for reconsideration in the past, to my knowledge, the commission has never reached a question of whether a party may file a motion for reconsideration or post-trial relief before the commission issues a written order. And that's, I think, the synopsis of where I'm going. Therefore, I believe the hearing officer acted appropriately and teed both issues up for commission decision today. ECMC Rule 521B provides that the commission orders must be entered within 30 days after hearing. No person may bring a judicial review action until the commission issues its final written order. In this case, the hearing took place on June 26th. The commission's written order was therefore due to be entered no later than July 28th, as July 26th, 30 days fell on a Saturday. However, the local governments filed their motion on July 23rd, which delayed entry of the final written order until the commission could rule on the motion. No ECMC rule allows for or prohibits post-hearing motions for relief. Therefore, ECMC Rule 517A, which provides that the Colorado Rules of Civil Procedure apply unless inconsistent with the Act or ECMC rules, requires us to apply the Colorado Rules of Civil Procedure. The local governments rely upon Colorado Rule of Civil Procedure 59A in their motion, which provides that a party may move for post-trial relief within 14 days of entry of judgment, as provided in Colorado Rule of Civil Procedure 58. CRCP 58 provides that after a decision by the court shall prepare a written judgment and the clerk must enter it in the Register of Actions. As applied to the commission, therefore, Colorado Rule of Civil Procedure 58 and 59 mean that a party must file for post-hearing relief within 14 days after the written commission order is entered. Based upon case law cited by KPK, I conclude that the local government's motion was premature and unripe and should be rejected. Should my fellow commissioners agree with me, I would direct ECMC staff and our council to issue a written order memorializing this decision today and the commission's oral decision on June 26 within 30 days from today. I would also inform the parties that they may file a motion for reconsideration or post-trial relief within 14 days of the date the written order is entered. So cutting to the chase, and this is not something that we see a lot of, when we make a decision, our AAGs and staff memorialize that in a written order. And once that written order is filed, CRCP 58 and 59 allow the kind of post-trial motion that the local governments are seeking today to be filed. The point being is that they filed it based upon deliberations only and not based upon the written order, because we never got a chance to file the written order because of the motion. So I would suggest that we direct staff to file a written order like we normally do, and then within the 14-day period after that written order, any post-trial motions for relief can be filed today. What that does, in fact, is allow the post-trial motions to be based upon not only the deliberations, but the actual written order. And that's important because during deliberations, commissioners are, kind of rambling in their deliberative thoughts, and commissioners may change their mind. And the written order does a good job of succinctly defining out what we actually did. And right now, we don't have the favorability of having a written order for any post-trial motions. So I think that's kind of where we are. In the interest of the public seeing and hearing, the commission should not be limited in what they say by the concern that their unscripted deliberative thoughts would result in a motion for reconsideration. So that's kind of why I think it's important to get the written order before we hear from post-trial motions. So those are my deliberative thoughts. It's not disallowing anything from the local governments, but it is allowing their motions to occur in concert with how we normally do business. And again, this is kind of issue that I've never seen before. I've never seen a motion for post-trial relief based upon deliberations only and before the written order. So those are my messy deliberative thoughts. Uh, would love to hear from others about what you think we should do from here. Commissioner Cross?
Thank you, Chair. I think you're spot on. As a former practicing attorney, I know sometimes the procedural issues can be annoying and frustrating, but they're there for a reason. And I'm in complete agreement with you.
Thank you for the deliberative thoughts. Others? Commissioner Messner?
Yeah, I think that makes sense. I think it does still create due process. I think it creates opportunities for the local government to still be able to file um, whatever they want to file after the order's out. I do think that the order does reflect decisions that we made and not just deliberations during the hearing. And so, while deliberations were certainly part of it, I think there were decisions that were made as well. And so, but I think it makes sense to have the order and follow what we've done in the past. So,
All right, AG Commissioner Oath, Commissioner Ackerman, any further deliberative thoughts? Otherwise, I'm going to seek some direction here. So AAG Davenport, let me try a motion for size, and then you tell me if I got it right. I would move that we deny the motions that are currently filed, that we direct staff and yourself to file a written order within 30 days of today, and that we allow any post-trial motions to be filed within 14 days of entry of the written order. Is that close?
That sounded good to me, Mr. Chair.
All right, we have a motion. Do we have a second?
second.
Motion and a second. Further discussion? Commissioner Oath.
Thanks. I think this will end up being reflected both by the record of your comments, Mr. Chair, and likely in the written order as well. But just to be clear that the basis for the denial is the procedural argument of being premature, not on the merits.
Yes, we are not reaching the merits at all today, and parties are directed that they will have an opportunity to refile based upon not only deliberations, but also the written order within 14 days of entry of the written order. So thanks for that clarification. Further discussion? All those in favor signify by saying aye.
Aye.
Any opposed? That motion carries. All right. We've got an oil and gas development plan up next. I need a little bit longer break. I've got to deal with something in my yard. Let's take 15 minutes. Let's return at 10:35.
Elected officials in Moffat County support them. I've seen a letter filed with the ECMC that expresses concerns over PRM's permit regarding wildlife issues. Sage grouse and big game management are certainly priorities within our county. Literally all of Northwest Colorado, including Moffat County, has some form of wildlife habitat that has been mapped by Colorado Parks and Wildlife. But that doesn't mean that economic activity cannot be compatible and happen within those same areas, especially when mitigation or impact minimization has been carefully planned for. In this case, as you're well aware, PRM has been working with Colorado Parks and Wildlife for 2 years to not only address the wildlife concerns, but to exceed any BMPs and standards regarding impact minimization. As far as Moffat County is concerned, PM has provided more wildlife benefit than exceeds any impacts they will be causing. PRM has committed to expensive noise mitigation on compressors, timing limitations to operate only 4 months out of the year, trucking hours, and paying significant money toward a conservation easement that will protect wildlife into perpetuity. In summary, whether PRM has been advancing in development or dealing with delays and setbacks in our county, PRM has been one of the most transparent companies to deal with in my 25 years as an LGD. The Moffat County Commissioners support this application, and I am happy to take any questions or discuss any of my comments further if you'd like.
Thank you, Mr. Comstock. Appreciate you being here on behalf of the relevant local government. We always appreciate hearing from the relevant local government. Do commissioners have questions?
Go ahead. I'm happy to take any.
Well, if we don't have questions, that generally means you did a pretty good job of summarizing your position. So thank you very much. We'll let you continue, and we will move to the applicant's presentation. If the applicant's lawyer and could raise and visualize all of the witnesses, the next step would be to get them sworn in.
All right, I think everybody is here and is visualizing now.
Should I go ahead, Mr. Chair?
Go ahead.
One quick clarifying question. I have Miss Laura Ardenson as on the witness list, but it's my understanding she's an attorney. Are you here as a witness or as an attorney?
I'm here as counsel. Thanks for checking.
Okay, thank you. So for each of the witnesses, I'll ask you to be visualized. When I call your name, please raise your hand, state your first and last name, and swear to tell the truth. We'll start with Duncan Shepard.
Thank you. I'm Duncan Shepard, president of PRM. I swear to tell the truth.
Thank you. Joy McKinley.
Joey McKinley, I swear to tell the truth.
Allie Oda.
Allie Oda, I swear to tell the truth.
Chris Cooper.
Chris Cooper, I swear to tell the truth.
Kelly Cox.
Kelly Cox, I swear to tell the truth.
And did I get everyone, Mr. McKee? You're muted.
I apologize. I believe so.
Thank you.
All right.
Is that showing correctly?
Yes.
I believe it's there. Chair Robbins, are we okay to go ahead and begin?
Go ahead.
Well, good morning, commissioners, ECMC staff, and members of the public. My name is Ryan McKee, and I'm a shareholder with Beatty & Wozniak. And with my colleague, Laura Aronson, we represent Petroleum Resource Management Corporation, or PRM, in docket number 240-800-186, which is an application for the approval of the Welba Peak 2 Oil and Gas Development Plan. This application is PRM's first OGDP application in front of the Commission. Later in the presentation, you will hear more about PRM, which is an independent, family-owned operator with deep Colorado roots. The Welba Peak 2 OGDP proposes to develop approximately 6,763 acres from one existing oil and gas location, the WPU 36-1 pad, and one partially constructed but unpermitted location, the Duncan facility, which will allow for the development of the Niobrara Formation. As a result of the unpermitted ECMC status of the Duncan facility, both the Duncan facility and the associated off-location flow line were previously brought before this commission for its approval of the final enforcement order issued pursuant to an administrative order of consent agreement reached between the staff and PRM addressing the partial construction of the Duncan facility and flow line. The Duncan facility was initially contemplated and planned for by PRM as a gas processing facility and permitted through the Moffat County process. As a result of modifications following its initial planning, the Duncan facility was more properly classified as an oil and gas facility under ECMC rules. Upon discovery of the nature of the Duncan facility following the engagement of a new regulatory contractor, PRM notified ECMC of its partial construction of the Duncan facility. Since the initial notification, PRM has worked diligently with ECMC staff to first properly secure, stabilize, and then shutter the Duncan facility, and has continued a collaborative engagement with staff throughout the resolution of the ECMC enforcement proceedings and now through the OGDP process, which has brought PRM before you today. And following PRM's remittance of a substantial penalty last month, the Commission's approval of this application today will bring the Duncan facility into compliance with all ECMC rules and outstanding enforcement actions. The Welba Peak 2 OGDP proposes to develop lands located entirely within and subject to the Welba Peak Federal Exploratory Unit, and as a result, a DSU is not being sought for this application. The OGDP also requests the Commission's approval of a variance to Rule 1003B to allow for a delay in the performance of interim reclamation at the WPU 36-1 pad to allow PRM to conduct its operations in a strategic manner that takes into account weather-shortened operational timeframes and other operational limitations associated with the overall Welba Peak unit development. Staff recommended approval of this variance request with certain conditions of approval relating to bonding requirements and timing commitments should operations proceed at a faster than planned pace. PRM agrees to and accepts these COAs. The Welba Peak 2 OGDP mineral development area is located within both Moffett and Routt counties, with both proposed locations being within Moffett County, the relevant local government. Moffett County does not regulate the siting of oil and gas locations. However, as part of its initial development plan for the Duncan facility, PRM obtained a conditional use permit from that location from Moffett County. And PRM would like to thank Moffett County for its participation in this matter today. While a portion of the mineral development lands are located within Routt County, both proposed surface locations are located over 2,000 feet from the jurisdictional border of Routt County, with the WPU 36-1 pad being over 2,200 feet and the Duncan facility being over 1.5 miles from the Routt County line. PRM's presentation today, along with the evidence in the record, demonstrates that the Welba Peak 2 OGDP allows for mineral development in a manner that avoids, minimizes, and mitigates impacts to the public, environment, and wildlife. A key highlight of this OGDP is the fact that the planned development will utilize an existing pad whose production will be routed to the Duncan facility, which has been planned to serve as a centralized facility for the whole of the Welba Peak unit development. The planned use of the Duncan facility as a centralized facility will not only eliminate the need for truck trips between the proposed wells and the facility, but will also, at this early stage of development for the Welba Peak area, provide for the transportation of produced natural gas to market through an in-place gas takeaway. Another highlight of this OGDP is PRM's efforts to help establish a nearly 870-acre conservation easement in the immediate area to help further mitigate potential impacts to wildlife. The Welba Peak 2 OGDP complies with all substantive and procedural requirements of your rules. There were 6 public comments received to this OGDP, with 5 in full support from local residents and 1 from Routt County expressing concern over the Duncan facility and the prevalence of HPH in the area. There were no protests received for the Welba Peak 2 OGDP. Finally, the director has reviewed all elements of the Welba Peak 2 OGDP and has recommended approval pursuant to Rule 306B1, finding that the Welba Peak 2 OGDP complies with all requirements of the ECMC's rules and, in the director's judgments, protects and minimizes adverse impacts to public health, safety, welfare, the environment, and wildlife resources. Joining me today to present is Joey McKinley from PRM. We will also have a panelist of subject matter experts to answer your questions following today's presentation. I will now turn the presentation over to Joey.
Thank you, Mr. McKee. Good morning. My name is Joey McKinley, and I am partner with Fielding Hill LLC, proud to be here on behalf of Petroleum Resource Management Corporation, or PRM. As Mr. McKee stated, PRM is grateful for the opportunity to present the Welba Peak 2 OGDP for your consideration today. PRM would like to thank Moffett County, ECMC, CPW, and CDPHE staff for all their time and attention throughout this application process. Because PRM is presenting its first OGDP before you today, we will provide a brief background of the operator, the surface stakeholders in the area, and the history of the Welba Peak development thus far. PRM is an independent oil and gas operator that has been contracted to operate the unit by the Welba Peak Group. In partnership with Carmody Exploration and an investor group of several small family-owned oil and gas companies, the Welba Peak Group has worked for almost 20 years to create and begin development of the federal Welba Peak unit. Many folks are familiar with the business models of publicly traded companies and private equity-backed companies, but the business model of family-owned oil and gas companies may be less familiar. Family-owned companies tend to build wealth over generations, and that is the kind of lasting investment we see with the Welba Peak Group, of which some of the member companies are in their second or third generation. These are individuals and their families personally investing over decades in the mineral development, the Welba Peak area ranches, and the surrounding communities. The Welba Peak Group has demonstrated significant investment of $54 million in the project area's leases and drilling, having only received 6 months of production from the most recent well that has been shut in since 2020 to abide by ECMC's no flaring rule. PRM has operated under an approved financial assurance plan since 2023, and as Mr. Comstock mentioned, assuming approval of eventual infill development of the unit, Moffat County may see several $100 million in ad valorem taxes at a time when the county is transitioning away from a coal-based economy. Because PRM is the operator of record, we will refer to them throughout this presentation. The Welba Peak unit surface is comprised of large ranches, many of which have been owned and operated by the same families since patent. Some parcels have small hunting or vacation cabins, and other areas are covered by large swaths of wildlife conservation easements and public lands. As you have seen from the letters of support received for this application, the ranchers in this area from both Moffat and Routt counties are supportive and interested in the success of the Welba Peak unit development. The Welba Peak Federal Exploratory Unit, originally formed in 2016, is situated in far northeastern Moffat and far northwestern Routt counties, less than 10 miles from the border with Wyoming. The unit is comprised of approximately 25,000 acres of both fee and federal minerals, with a unit obligation to drill 2 wells per year. This obligation is currently suspended pending approval of this OGDP. The unit is currently in an exploratory phase, meaning that new acreage must be drilled to hold it within the unit. As demonstrated with the $54 million investment thus far, and only 6 months of production from the only producer, and by building gas takeaway and a gas processing facility before fully delineating the production capacity of the area, PRM is invested in the long-term development of the unit and successfully navigating the ever-changing regulatory landscape. As previously stated, the Welba Peak Group has worked for almost 20 years to establish the Welba Peak unit. Initial work began around 2006 with outreach to area ranchers and execution of the first surface use agreements. In 2012, the spud of the Sheehan well unfortunately resulted in a dry hole, but it did provide valuable geologic data. The Sheehan well was subsequently plugged and abandoned, and that location is considered by the reclamation staff to be fully reclaimed. In 2013, PRM obtained special use permit approval from Routt County for their Wiregrass location that was, at the time, contemplated to be a production delineation location. Later, ECMC also approved permits for the Wiregrass well pad. In 2015, PRM shifted focus from the Routt County location to what is known today as the existing permitted WPU 36-1 well pad and spud a vertical well. In 2017 and 2018, PRM expanded its exploration with 1 mile and 2 mile horizontal sidetrack tests. In 2020, the existing producer was shut in to abide by the no flaring rule, and PRM began planning for gas capture. In 2023, PRM obtained county permits for the Duncan facility and associated flow line and began construction. As Mr. McKee mentioned, this hearing is not the first time you've considered action related to the Duncan facility. As you likely recall, on July 30th, you approved settlement of a violation related to partial construction of the Duncan facility. As you saw in filings associated with that enforcement matter, PRM, under the direction of previous consultants, mistakenly constructed the Duncan facility location without first coming before you for an OGDP. The fine for this enforcement matter has been paid in full, and we cannot reiterate enough how seriously PRM took addressing the resolution of that violation once they realized they were not in compliance. As you will see, PRM has since been meeting and consulting with ECMC and other agencies, but we wanted to directly address the correlation between PRM's NOAV and this OGDP, as it is a unique factor going into this OGDP review. Now let's dive into the OGDP. The Welba Peak 2 OGDP consists of two locations, the partially constructed Duncan facility and the existing permitted WPU 36-1 well pad. The Duncan facility is located on fee surface and will house production facilities for approved well pads within the Welba Peak unit. Additionally, a Class 2 injection well is proposed on the Duncan facility for disposal of produced water. The 36-1 well pad is located on fee surface, and PRM is proposing 4 horizontal wells that will access both fee and federal unitized minerals. The existing shut-in well is situated on this location, and that well is not part of this OGDP. Additionally, there is an approximate 4-mile flow line connecting the locations where 3-phase production will flow from approved well pads to the Duncan facility. From there, oil will be trucked to nearby first purchaser facilities, and natural gas will be gathered to a small gas processing facility near Baggs, Wyoming. Next, we will take a look at each location. The Duncan facility, named after the surface owner, Duncan Livestock Company, is proposed to disturb a total of 12.04 acres, which includes previously constructed disturbance and proposed expansion. The flow line that will bring production from approved unit wells to the Duncan facility disturbed approximately 34.3 acres. Once interim reclamation is complete, only 4.84 acres of long-term disturbance will remain for the Duncan facility, the proposed UIC well, and the access road. The location is compliant with siting and setback rules. The nearest RBU is situated approximately 3,500 feet northwest of the Duncan facility, and the central facility was strategically proposed in this location because it is so far away from the nearest RBU. The facility is intended to serve not only the existing well and the proposed 4 wells, but future proposed and approved unit wells. Because the facility is intended to be in existence for the life of the unit, PRM cited the location to be as far away from RBUs as possible. Diving into specifics on the WPU 36-1 well pad. This existing location and its access road has a total of 6.61 acres of disturbance with a current working pad surface of 2.54 acres. Some of the agency communications indicated otherwise, so we want to clear up any confusion. No additional surface disturbance is proposed at the WPU 36-1 location in this OGDP. After drilling and completions of the 4 proposed wells, PRM will complete interim reclamation, bringing the total long-term disturbance down to 2.38 acres. An RBU is situated at 1,075 feet from the working pad surface. That RBU is not a primary residence, and it is temporarily or seasonally occupied. PRM obtained informed consent, and the owner of the RBU is also the surface owner of the well pad and the Duncan facility. Coordination with all relevant agencies is key to the success of this project. So in the next several slides, we will review those consultations. Agency consultations for locations within this OGDP began as far back as 2017. PRM has closely coordinated with Moffat County for county road maintenance, and the county has received multiple OGDP notices. Coordination with CPW has been a key component in PRM's planned development of the Welba Peak unit. PRM consulted with CPW extensively, and CPW approved PRM's wildlife mitigation plan. We will discuss the compensatory mitigation plan in an upcoming slide. Critical to gas capture, PRM operates a gas processing facility for the Welba Peak development near Baggs, Wyoming. PRM has consulted with multiple Wyoming agencies through the process of permitting and constructing this site. A formal consultation with CDPHE occurred in July of this year. PRM engaged in additional consultations with CDPHE for air permits and monitoring plans, as well as stormwater permits. The Welba Peak 2 OGDP will develop federal minerals, and the BLM has consulted several times throughout the development of this application, with BLM APDs currently pending, and the BLM has approved the off-lease metering plan proposed at the Duncan facility. Last and certainly not least, PRM consulted with ECMC staff many times in the development of this OGDP application that was submitted in August 2024. The Welba Peak unit is situated in an area almost entirely covered by CPW high priority habitats, as shown on this slide by the coverage of many townships in yellow. The far southern portion of the unit, where the WPU 36-1 well pad is situated, does not have terrestrial wildlife habitat designations, but some streams are protected as aquatic habitat. As you can see, avoidance of high priority habitat is not possible in the development of this federal unit, so minimization of disturbance and mitigation plans are critical to the protection of wildlife resources. The WPU 36-1 is situated within Rule 1202C1R for aquatic native species conservation waters covering the perennial roaring fork of Slater Creek west of the pad. PRM obtained a waiver from CPW for Rule 1202A3 for the transport and possible temporary storage of chemicals during drilling and completions. No permanent storage is planned during the production phase. This location does not have any terrestrial wildlife timing limitations. The Duncan facility does not interact with any 1202C no surface occupancy habitats. It is, however, situated within both Rule 1202D for density and 309E for consultation high priority habitats specified on this slide. CPW timing limitations for these species span from November 15th through July 15th annually. This only allows for a 4-month window annually for major operations. As we will demonstrate in a later slide, PRM's operations will abide by these timing stipulations. While developing this OGDP application, PRM worked with CPW to develop a compensatory mitigation plan for the direct impacts of the Duncan facility as a Rule 1203B operator completed mitigation project in lieu of simply paying mitigation fees. The compensatory mitigation plan details that in 2024, PRM, CPW, and Colorado Open Lands purchased a perpetual conservation easement in the vicinity of the Welba Peak unit. This easement links together several existing conservation easements and prohibits development and land conversion. This easement also helps protect more than 800 acres of greater sage-grouse, elk, and mule deer high priority habitat. PRM supports conservation efforts and is appreciative to CPW, Colorado Open Lands, and the surface owner for the opportunity to be a part of this significantly beneficial conservation easement and mitigation project in proximity to its operations. Next, we will discuss the disproportionately impacted community. Moffat County is populated by just over 13,000 people. Of these, approximately 70%, or around 9,000 people, live in or near the city of Craig. Approximately 4,000 people populate the rest of the county, which is the second largest in Colorado by land area. So it's easy to visualize that the Welba Peak development area is sparsely populated. Since this OGDP was submitted in August 2024, the CDPHE EnviroScreen 1.0 was used to assess demographics and climate impacts of the population for this area. As shown on the right-hand side of this slide, the 2024 DI community is a Justice 40 tract, with the primary driver being a climate vulnerability score of approximately 97. EnviroScreen 1.0 also designates this area as a low-income population. This area has an EnviroScreen 2.0 score of 32.85, and it removes the low-income population designation, reduces the climate vulnerability score from approximately 97 to 49, and it increases the sensitive population score from approximately 68 to 86 for higher rates of diabetes, mental health indicators, and disability. Now we will review the alternative location analyses. For the 36-1 well pad, PRM requested and CPW granted a waiver of ALA in favor of reoccupation of the existing well pad. However, because of the RBU, CDPHE and ECMC did not allow for an ALA waiver. Any alternative location would require new disturbance. 2 of the alternative locations would be entirely situated within the aquatic high priority habitat and require variance applications. Two of the locations would be closer to the RBU. So ultimately, the proposed location was found to be the least impactful, and the landowner also preferred this location over any of the alternative options. Now let's look at the Duncan facility ALA. During planning, a separate pad location was considered for the UIC well pad, and during the onsite with BLM and ECMC, PRM decided to propose expansion of the Duncan facility to co-locate the UIC well with existing disturbance. Also, PRM identified the location of the Duncan facility because it is adjacent to Moffat County Road 1 and next to a large area of the rancher's cattle operations that has existed for more than 50 years with corrals, hay storage, and equipment storage. The area is accustomed to truck traffic in that location for the ranching operations. When analyzing the alternative locations, all of the locations are in the same or similar density and consultation high priority habitats, and one of the alternatives would be situated in a geologic hazard area. Two of the alternative locations are immediately upgradient from wetlands, riparian areas, or a perennial stream. And PRM found that the man-made buffer of Moffat County Road 1 between the Duncan facility and downhill water resources would be more protective of those resources. Ultimately, the proposed location was found to be the least impactful location. Now we will review the major BMPs for this OGDP. As mentioned, HPH avoidance is not possible to develop this federal unit, so BMPs are critical to ensuring the least impact. Some key BMPs to note are dawn to dusk production hauling during more sensitive wildlife season at the Duncan facility, compressors that will be fully enclosed with only the cooler fans and exhaust outside the building with no openings or gaps to minimize noise at the Duncan facility, as well as PRM will abide by the Duncan facility's CPW timing limitations from November 15th through July 15th. PRM will use Group 3 mud for the proposed horizontal wells at the 36-1 well pad to minimize emissions near the RBU. And of course, the highly protective compensatory mitigation plan and the purchase conservation easement. This OGDP application proposes disposal of produced water via the WPU 14-1 PWD number 1 UIC well, removing trucking impacts. You can see in the table on this slide that depending on the formation's tolerance for injection and average injection rate, disposal of produced water can eliminate anywhere from 3,000 to 30,000 trucks annually. The produced water rulemaking occurred after submission of this OGDP application. However, understanding that rules for recycling and reuse are forthcoming, PRM has been exploring options for compliance. Permanent produced water storage options are not currently permissible due to the area's designation as a disproportionately impacted community. Until such time as permanent storage is allowed, PRM continues to explore options for temporary storage and reuse, as well as making use of the credit system. The centralized nature of the Duncan facility makes it the best option for siting any temporary or, if allowed, permanent storage. Now we will review key timing considerations for operations. Because it may take 2 occupations of the 36-1 well pad, and PRM needs until the season after finishing major operations on the last well to complete interim reclamation, PRM requests 24 months from approval of the variance application to begin interim reclamation. PRM's operations timeline for the Duncan facility is outlined on this slide. As depicted, if this OGDP is approved, PRM intends to act quickly to begin construction of the Duncan facility upon approval of the Form 2A. This is to ensure compliance with CPW high priority habitat timing limitations that begin on November 15th. Also to ensure compliance with ECMC rules, PRM has submitted all CPW, surface owner, and relevant local government notices, as well as an ECMC Form 42 notice of construction. To help ensure that PRM can abide by the HPH timing limitations, PRM very much respectfully asks for staff's timely finalization of the web forms. Yesterday, PRM conducted a pre-construction meeting with contractors for planned operations at the Duncan facility. During this meeting, BMPs and COAs agreed upon were discussed and expectations were outlined to all contractors. PRM will submit a Form 3A upon receipt of an approved Form 2A to update financial assurance. At this time, all bonding requirements have been met for the Duncan facility. Additional bonding will be remitted to ECMC for the WPU 36-1 location, assuming approval of the variance application. I will now hand the presentation back to Mr. McKee for conclusion.
Thank you, Joey. Next slide, please. This marks the final slide in PRM's presentation today and represents a final overview of how the Welba Peak 2 OGDP avoids, minimizes, and mitigates potential impacts to the public, environment, and wildlife. The Welba Peak 2 OGDP will allow for the mineral development of over 6,763 acres from one existing oil and gas location, which will not require any additional surface disturbance, and one proposed facility that will serve as a centralized facility not just for the proposed development, but for the planned greater Welba Peak Federal Unit development. The use of the Duncan facility as a centralized facility for the whole of the Welba Peak development will allow for the elimination of additional facility-based disturbances and the elimination of additional oil truck traffic from well pads to the facilities, which will not only reduce emissions impacts, but will also lessen traffic impacts and potential safety concerns related to large truck traffic on mountain roads. PRM's utilization of an existing location, the WPU 36-1 pad, which again does not require any additional new disturbance, further mitigates and minimizes impacts to wildlife, and as a result, CPW supports this OGDP. And while the relevant local government, Moffat County, does not regulate the siting of oil and gas locations, Moffat County is in full support of this project and, in fact, initially approved a local permit for the Duncan facility. And PRM would again like to thank Mr. Comstock for taking the time to offer the county's perspective to the commission today. As we stated earlier, no petitions were received against this OGDP, and 5 public comments were provided from local residents in support of this application. And following the public comment period, we received 1 public comment from an adjacent jurisdiction that was in opposition to the Duncan facility. Lastly, as we previously mentioned, pursuant to the director's recommendation, the Welba Peak 2 OGDP complies with all requirements of the Commission's rules and, in the director's judgment, protects and minimizes adverse impacts to public health, safety, welfare, the environment, and wildlife resources. We want to thank staff for its thoughtful technical review of this project and the director's recommendation for approval. Finally, we'd like to thank you, the commissioners, for your attention to today's presentation. And this will conclude our presentation, and the panel is now available for your questions. Allie, you can stop the screen share.
All right. Thank you for the presentation. If all the witnesses could visualize, the next step in this process is commissioner questions to the witnesses or counsel. Commissioner Messmer.
Thank you, and thank you for the presentation. I've got a number of different questions, and so I'm going to jump around here a little bit because I'm trying to better understand some of the elements of the application here. So I apologize if I'm jumping around a little bit. But maybe a big picture question first. I think throughout a lot of the application and the submittals associated with the application, the Duncan facility is labeled as a centralized production facility, and right now understanding that it's contemplating the utilization of this one pad to serve that production facility, but also understanding that there are some lease terms associated with this area that I think you've indicated in your presentation include a requirement to drill at least a couple of wells a year or something like that. Can you talk a little bit about what some anticipated future uses of this area may be, and whether or not the Duncan facility would truly be a centralized production facility serving more than just this one well pad or not?
Thank you for the question, Commissioner. Yes, PRM has a pending OGDP following this one for its next planned well pad, which would also flow production from the well pad through the constructed flow line to the Duncan facility, again, where oil, gas, and water are dispersed. PRM is also contemplating temporary and, if allowed by statute, and ECMC, permanent storage of produced water for reuse, recycling, for its future operations to be in compliant with the forthcoming rules. And so, yes, more OGDPs are planned to be submitted, and additional equipment, if ever needed, on the Duncan facility will be applied for at a later time.
Okay. Thanks for that. And then I wonder if you could talk a little bit about oil takeaway, where the nearest sail line is. One of the challenges I think with the Duncan facility is the lack of connectivity to oil takeaway, and especially in its contemplated utilization as a centralized production facility for multiple well pads and the associated truck traffic that would be incorporated with the lack of oil takeaway. So could you talk that a little bit?
Yes, thank you for that question. We would love to touch on this. Yes, oil pipeline transfer or takeaway is considered for future applications. It is necessary to build up average daily production to feed such a pipeline. So until that time, and while PRM cannot commit to oil pipeline takeaway for this OGDP, they have begun working on right-of-way agreements and future applications that contemplate that execution. As far as the nearest sales line, I will ask Mr. Shepard to speak to that.
Thanks, Joey. Right now, as Joey mentioned, the oil gets trucked to one of two locations. It's either Wamsutter, Wyoming, or there's also an opportunity down in the Craig, Colorado area. And again, as Joey pointed out, initially, one well, there'll be smaller volumes, but we've actually already begun talking to landowners about a potential expansion of pipeline capacity out there in the future. To get to that point, candidly, we have to drill a few more wells to confirm and prove up that we're going to have multiple well productivity.
Okay. And I'm asking some of these questions because one of the evaluations that I have to do as a commissioner is look at reasonably foreseeable future development. And so when you talk about needing, a certain number of additional wells, and also understanding that you've got one well there, and so that you're still engaging production, so I acknowledge that. But are we talking about 5 new well pads? Are we talking about a couple of well pads? I mean, what is that tipping point for making that determination for oil takeaway?
Thank you, Commissioner. I think that our viewpoint is, okay, when we get another pad, which would be the next OGDP, that delineates maybe a third of the project. And so in general, if we can step out yet another pad, then at that point, understanding the lead time that's required, yeah, we're going to start, assuming everything confirms the productivity, we're going to start expanding the pipeline capacity, which could include oil takeaway capacity. I should point out our near-term expectation is if we start to get a handful of wells out there, our gas pipeline takeaway is going to be filled up. So by definition, we're going to have to plan additional takeaway capacity out there. So once you're doing that and you've got rights of way, you can put in an oil line takeaway at the same time.
Okay. Appreciate the answers to that. That helps provide a little better perspective for me. So one of the other questions I have is I'm scratching my head a little bit around the pipeline. The gas takeaway pipeline was constructed previously, and then there was kind of retroactively a waiver that was provided by CPW that BMPs associated with that waiver for trenching through the stream required biological monitor to ensure that the BMPs were being implemented correctly. At least in the literature that I'm reading in the director's recommendation, it seems like the record of that biological monitor has gone missing. I wonder if you could talk a little bit about what happened there and how do we know that those BMPs were followed?
Thank you for the question, Commissioner. I don't believe that the records went missing. There was a transition of consultants around that, not long after that. And I don't know that we weren't able to turn up the email communications if any existed, which we believed that there were, as well as any other notes that occurred during that time. However, my colleague, Mr. Chris Cooper here, I believe was part of those efforts at the time and can swear under oath that a biological monitor was present for that trenching. And it was only one of the 3 crossings that was trenched, and that was because they ran into just a technically infeasible situation in the field. Mr. Cooper?
Yes, thank you. And I can swear to that testament that a biological monitor was present during the time of construction. As Joey mentioned, it was a real-time issue that we ran into, or PRM ran into while putting in the flow line pipeline. And this was a real-time CPW consultation. I mean, picking up the phone, not emailing, and talking through this and how we could set this up to be successful and meet CPW's expectations for BMPs and protecting that stream and that HPH designation during the open trench.
Okay, thank you, Mr. Cooper.
Yes, sir. Thank you.
So one of the other questions I had was associated with truck traffic and some inconsistencies and some different submittals that you provided. And so I'm not really sure what the anticipated truck traffic is. So what I've got here based on submittals is that you're anticipating, according to the wildlife plan, 3,000 truck trips a year. According to the Form 2B that you submitted, it's 240 truck trips per year. And then according to your cumulative impacts plan, it's 12,000 truck trips a year. And so I'm not sure what's accurate there.
Thank you for the request to clarify, Commissioner Messner. Apologies, not having those 3 specific documents pulled up. What I can speak to is what I believe should be the latest information supplied in the OGDP, as well as noted on the Form 2B. And let me look at that. Are we speaking about the Duncan facility specifically?
That's correct.
Thank you. So I believe we note that.
And sorry, let me clarify that too. I'm just
Sure.
talking about production.
Thank you. Thank you. So we did revise through the completeness process. We received feedback for another OGDP where staff noted that they preferred to see produced water being trucked for the duration of production until the injection well is approved for disposal. And then we could sundry to remove those truck trips. So we decided to go ahead and supply that, or apply that methodology to this OGDP as well. So for the life of the pad, the Duncan facility, we propose that there may be 120,000, excuse me, that's large equipment transportation and potentially 22,000 pickup trucks over the life of the well if we're assuming 30, or the pad if we're assuming 30 years. That gets us to a total of around 142,350. Most of those truck trips are going to be removed upon approval of, assuming approval of the injection well.
Okay. So I'm asking this question because I have to gauge impacts associated with truck trips. And I acknowledge that at least there's commitments, BMP commitments in the in the application that talk about produced water takeaway and injection wells. And so I acknowledge that. So can you help me understand how many truck trips are associated with the production of oil on an annual basis from this location associated with the one well pad that's being contemplated here, which would be one existing well and 4 new wells?
Yes. Thank you for the clarification. So for oil, we are looking at, I believe, the calculation is that, okay, if I may read a statement that is in the plan. The truck trips contemplated here are intended to be the most conservative case. Remote equipment monitoring and takeaway of oil via pipeline are anticipated to be proposed in the next 1 to 2 years. The most conservative case is calculated as follows. The location is anticipated to be visited daily for the life of the pad by a production operator in a pickup truck as indicated by the once daily times 365 days times 30 years for a total of 10,095 pickup trucks, which you double that and you get the approximate 22,000 trips. Semi-truck trips during the production phase for the life of the pad are calculated as 10 semi-trucks per day during the first 3 years and 5 semi-trucks per day for the remaining estimated 27 years. So I think when production is initially heavy when the wells first come on, we're anticipating perhaps 10 per day for oil takeaway, and then as production declines, approximately 5 per day. And we have structured the equipment proposed on the Duncan facility such that there would be enough storage for the dawn to dusk trucking during a majority of months of the year. I apologize, you're muted.
You're muted, John.
Yep. So that's the number we're going to go with oil takeaway is 10 per day for the first 3 years, 5 per day for subsequent years. Is that?
Yes. And if one of my colleagues could quickly calculate for that for me, that would be great. I'm not going to try to do math on video.
Okay, well, that's helpful to better understand what's being proposed. And then I did have a couple other questions about the Form 2B. And so I'm looking at the Form 2B that's on our website in the application. There could have been modifications to this Form 2B that I may or may not be aware of, so I acknowledge that. But as I'm looking at the Form 2B, the Form 2B is contemplating 20 monthly truck trips. And so that's clearly inaccurate based on what you've indicated here now. And that's also, at least I believe in the narrative of this, anticipating to include produced water takeaway for some amount of time. And so this Form 2B does need to be accurate as it's an important tool for evaluating cumulative impacts. And so I have I see some problems there. In addition, there are elements in the Form 2B around production as it relates to emissions that the numbers are just zero. And so I don't really, that can't be.
Thank you, Commissioner. If my colleague Kelly Cox is available to speak to that.
Yes, hi, I'm Kelly Cox. Thank you for the question. I think it's fairly important because I do know the changes that there were a few changes to the 2B. And I know that there's also two separate 2Bs that were filled out, one for the Duncan and one for where the wells are operating. So I don't know which emissions section you're talking
So
about.
help me just for a second here. And I do know that there's two Form 2Bs and so the production facility is going to have a significant amount of storage associated with it, correct?
Sure, yes.
And so, for example, I'm looking at the Form 2B for the Duncan pad for production emissions, which includes storage tanks, and process heaters and boilers and stationary engines and turbines and separators and different elements that may be incorporated into a production facility. And the emissions are zero. At least what I'm looking at, there's just anticipating zero emissions. And so that doesn't seem accurate to me. I'm just asking.
Yeah, sorry, that does not seem accurate to me either. So I don't know if you're looking at the correct form. So if you're looking at the Duncan facilities emissions, and you're saying that the production section for storage tanks is zero? For for instance, for storage tanks at the Duncan facility, I see 65 tons of VOCs. Sorry, you're muted again. I'm sorry.
That's okay. I've got a puppy over here that's tearing stuff up, and so I'm trying to.
Understood. But so do you see the 65 tons of VOCs on that same line item or no? So at the Duncan facility for the pre-production stuff, obviously there's no information for storage tanks for the pre-production information. But on the production line item, you should see certainly emissions for storage tanks.
Yeah, I think there needs to be some clarification here because I'm looking at it and I'm seeing zeros for production emissions associated with VOCs, with HAPs, with the everything. It appears that there's some confusion here, and this is the Form 2B that's on the website that I utilize in my evaluation, so we can sort some of that. We'll have to sort some of that out, but there seems to be some inaccuracies there. Or at least I need to get the right things in front of me so that as I'm looking at this stuff, I'm having the correct information. So
yes, certainly I can work to make sure you have the right information. But I can also generally review what the emission, I don't know what's helpful or what would be helpful at this
I don't think
point.
we can do that on the fly here. So I'm gonna put a pin in that right now, and I'm gonna follow up on this in a second. So
sounds good.
Yeah.
Thank you.
Give me just a second here. I've got a couple of other questions, I believe. Oh, one question I had, and I appreciate that you're feeling pressure in order to be able to go through a process like this prior to the timing steps occurring in November 15th, I think is when they start. But I wonder if you could talk a little bit about kind of the pre-completeness timing and some of the application processes here, where at least in some of the information I was reading about, there was, up to 80, 90 days between staff sending it back to draft and it coming back to staff. And it feels like while I acknowledge the pressure of the timing steps here, there was a lot of delay associated with some of the submittals coming back to staff in the application process. And I have to weigh that a little bit in, determining kind of the expediency. And I understand that you've submitted a Form 42, which indicates that you want to begin construction after any kind of verbal decision that's made by this commission, which obviously wouldn't be allowed by the rules. There's processes that needs to follow and timing associated with that. And so as I look at the totality of the review process here and some of the delays that occurred early on, I'm just trying to better understand what happened there, or what was the need for that additional time in bringing submittals back.
Thank you for the question, Commissioner. And I would like to clarify that PRM has revised its Form 42 to be exactly what I stated in the presentation, which is that PRM will wait until an approved Form 40, or excuse me, 2A comes through in web forms before beginning work at the Duncan facility. As far as the application process over time, PRM submitted its application in August, in August of last year. At that time, we were also working to resolve any of the compliance issues noted in the NOAV, and some of those intertwined with the OGDP application. And so as things or events evolved with the compliance resolutions, that also occasionally changed what needed to go into the OGDP application. We also had a situation where the civil drawings, we needed to make a pretty significant improvement to them, and it wasn't caught until after the first completeness. Unfortunately, that resulted in needing to revise every document, because when you change the disturbance, you change the acreage, you change every document in the OGDP. I don't believe that the OGDP application was at all lacking in quality. I think this was a unique situation that staff and the Fielding Hill team and PRM explored how to resolve in the best ways to be most protective of resources and ensure compliance with ECMC rules. And as a result of that, we went through more rounds of completeness than I personally prefer.
Okay, thank you for the response. Last question. Understanding the federal unit that you're in and the what I'm understanding is kind of bigger plans for the area. Has there ever been any consideration of the utilization of a comprehensive area plan for this particular area, which I think could tie in to kind of the federal designation of this particular area?
Yes, thank you for the question, Commissioner. Yes, in fact, PRM is working on its next OGDP applications so that to kind of catch up ahead of needing to be ready for construction in the appropriate season ahead of SPUDs. And then also along with that, we are working on a cap that would show the rest of the development. So it's coming. In fact, we've also met with the BLM about developing a master plan of development with them in sync with the CAP.
Okay. Those are my questions for right now. Thank you for answering them. I do, Mr. Chair, I may have a couple questions for Mr. Taylor Elm from CPW, but I'm going to wait until other commissioners have an opportunity to ask some questions. So,
All right, sounds good. Thanks for the questions. Others with questions for the panel? Commissioner Ackerman?
Thank you, and I appreciate Commissioner Messner's extensive questions. I just have a couple to add to that. I couldn't find really timing information on the conservation easement that you're working on. Has that already been completed? Is it pending? Can you kind of give me an idea of the status of that?
Yes, Mr. Commissioner, thank you for that question. It has been executed and is in place at this time.
Thank you. I appreciate that.
Yes, sir.
And I maybe I missed it in the explanation, but I'm still a little unclear on the existence of biological monitoring data from the equipment that you talked about. I think what I'm hearing is that it was taken, but we still don't have access to the data. Is that correct? Can you verify?
Yes, we did have biological monitors in the field daily during in-stream construction. The notes, what Joey was referring to, and GIS information from another consulting firm has not been made available, and we're having trouble pulling those emails back and forth for those. However, going forward, there is a robust process as far as biological monitoring goes for PRM. And we're actually in the middle of that right now with another project that ECMC has directed for PRM to complete with a biological monitor on site during construction, in the ordinary high water mark. So those are daily recordings that get recorded with photographs. It's stored on a central server. So we should not have issues with any of that request going forward as far as producing the data.
Thank you, Mr. Cooper. I appreciate that. And so to put a finer point on it, is there any hope of recovering the biological data that from the past monitoring?
We have asked. We did get a few items, but nothing that was substantial. We had some timesheets and stuff that showed that a biological monitor was present for the week, but again, the notes are missing. Following this in the roundabout with CPW, once the project was complete, again, this was a Thursday afternoon phone call. It was something that was real time. Sent monitors out. The project was complete. CPW did find no adverse effects to the stream following their follow-up site inspection when the open trench was completed. Of
Yeah,
course,
thanks.
Yes, sir. Thank you.
I'm sorry. Thanks for making that point. I was also going to note that CPW was on site after the fact, and one of the many complications associated with the the irregularity of the process with this OGDP, including kind of the ex post facto ALA, makes it a little odd and difficult to kind of ensure that we have all the data. It looks like we've rectified that. Do you have any issues sharing that? I know that CPW and you have been talking extensively. I believe you've talked about biological data going forward. Any issues with sharing that with CPW as it moves forward?
Absolutely not. No. And we're ready at any time for requests from CPW for those notes or those files. And that's to date with other projects going on. So no issues providing that to ECMC or CPW going forward.
Thanks. I appreciate that. I don't have anything further, Mr. Chair.
Thank you, Commissioner Ackerman, for the questions. Further questions for the panel? Mr. McGee?
Yes, I do believe I was going to ask Ms. McKinley to go ahead and address some of the additional issues that Mr. Messner raised regarding the 2B. I think there may have been some web form issues, and I think Ms. McKinley can address that.
Go ahead, Ms. McKinley.
Thank you, Commissioner. During the completeness process, PRM revised its Form 2B and requested that those updates be applied. But it appears that the version that you may have access to is not the latest. So apologies for that. I welcome ideas on how to resolve that.
All right, so the Form 2B that we have before us is not the correct Form 2B. Is that right, Ms. McKinley?
That is what we believe. Yes.
Chair Robbins, it sounds to me that what is submitted to web forms is the accurate one, but what is available on the website wasn't uploaded. So I think staff has both the correct web forms, but the public, the one that is available, is not the correct web form. So.
Okay, thanks for the explanation. Mr. Boudreau?
Mr. Chair, I believe Miss Emily Waldron, who is the location assessment specialist, might have some information to offer here.
Let's bring her to the panel. Good morning, Ms. Waldron. Have you been paying attention to the discussion?
Yeah, I have. And I'm in web forms right now, and I think I know where the confusion is from. The way that the PDF of the Form 2B prints out, there's a very small line that identifies which location the production numbers are talking about. There's only one 2B for each OGDP application. The individual location impacts are broken down within that overall 2B. So on page, let me make sure I'm telling you this correctly. So on the PDF version of the 2B, the emissions being talked about, production emissions, I believe, Commissioner Mesner, that would be on page 5 of the PDF. Those refer to the WPU location. Those zeros are correct. There's no equipment planned for that location. If you scroll down to page, I think it's 12, those are the production emission numbers associated with the Duncan facility. And at least on my report and within web forms, there are no zeros there, and the web forms numbers and the PDF numbers are the same. So I hope that adds a little clarity to the 2B discussion, and I'm happy to answer any questions.
Commissioner Messner?
Yeah, thanks. And I do have I do have some questions because even as I go down, it feels like there's so for example, you're saying like on page 12, that would be the production facility, correct?
Correct, the Duncan facility.
So there's storage tanks on that.
Correct.
I'm having to look at it again here. So no storage tanks for pre-production, right? And then we've got storage tanks for, okay, so there are some, I see it now. Okay. Thanks, Emily.
No problem. Happy to help.
Mr. Chair, you're muted.
Thanks. Okay, I'm not seeing further questions. So the panel can unvisualize. We'll bring it back to the commissioners for deliberations. All right. Commissioner Messner, I was going to call on you, but you've unvisualized.
I'm here. My internet connection just got unstable for some reason. So can you hear
You've had a lot of really good questions. Do you want to engage us in deliberations?
Yeah, I'm a little all over the place with this one. It feels like there was a lot of process to go through in order to get here. It feels like there certainly was an attempt to try to put all the pieces together and, craft something out of a situation that was completely inappropriate. I'm not convinced that the Duncan facility is the best location. I think it's has come down to what many are seem to think is an acceptable location based on a bad situation. I think that location, the Duncan facility, was cited because it was close to a gas takeaway line and it worked functionally, but I'm not sure holistically as you look at citing something like this, if you were to start from scratch, that would be the best location. At the same time, there was an AOC that was developed associated with that. And so I'm looking at this with what the application holds, and and only that. I have some concerns with whether or not the applicant has fully looked at in their cumulative impacts plan associated with 304C19 the reasonably foreseeable future development, the kind of contemplating the overall potential utilization of this area, and whether or not the utilization of the Duncan facility as the centralized production facility for many well pads associated with this particular area, and whether or not that's an appropriate site. And so I do have some heartburn that comprehensive level planning, the cumulative level impacts evaluation of this Duncan facility in particular is fully been contemplated in this application. This isn't a comprehensive area plan application, and I acknowledge that. It's an OGDP in front of us, and it's got certain things that are associated with it. But in testimony, the applicant has provided that this could be the base or the stepping stone for future utilization of this centralized production facility. Not having that oil takeaway as I look at potential future utilization of this Duncan facility does give me heartburn, although I appreciate that a certain level of production has to be developed in order to be able to invest in the necessary infrastructure to get oil takeaway to this location. I think if it's to be contemplated as a central production facility, that need for oil takeaway or three-phase takeaway or two-phase takeaway or whatever infrastructure needs to be contemplated or developed, makes sense. And, this really would benefit from a comprehensive area plan. And so I think whatever the decision I make today on this particular facility, I'm not sure that I am invested that the Duncan facility is the appropriate location for a larger scale centralized production facility associated with many well pads in this particular area. Is it potentially appropriate because of the circumstances that we find ourselves in for the one location that it's contemplating? I think it's possible. I do think that getting better clarification around the truck traffic associated with that, because man, the numbers were all over the place, and I think we got some clarity today on what those numbers are, but those numbers are different than the numbers in the wildlife mitigation plan. The good news is, if my math is correct, which I do worry about, it does appear that the truck traffic that is committed to today is less than the truck traffic that's contemplated in the wildlife plan. And so that's a good thing. And I appreciate that they're looking at ways to meet the timing stipulations associated with the wildlife plan. And I appreciate that. I feel a little bit like there's unnecessary pressure placed on this commission to make a determination here based on the timing steps associated that was purely applicant driven. And so, I do worry whether or not that level of comprehensive planning and whether that evaluation of cumulative impacts has been adequately done at this point. especially understanding the potential future utilization of some of the facilities that are being contemplated in this OGDP. And so I think I would like to hear other commissioners' thoughts on this prior to making any kind of statement on where or not I'm leaning, because I'm really not sure right now. I need the benefit of other commissioners' thoughts on this, but I do find it a little bit of a challenging situation as I look at everything. So.
Oh, and not to make a challenging situation more challenging, but I'd like to call on AG Boudreau to get attorney advice relevant to timing of this application, relevant to the cumulative impact rules, which rules we're supposed to apply. All of that is relevant, I think, to some of the, I think, good points that Commissioner Messner made.
Thank you, Mr. Chair. Yes, it's my understanding this application was filed prior to the cumulative impacts rulemaking rules becoming effective. If we're talking about reasonably foreseeable cumulative impacts, I believe that was incorporated as a result of the cumulative impacts rulemaking and does not necessarily apply to the rule set that was effective as of the time that this application was submitted. So I would just note that.
So, Mr. Chair, I do have a comment to that. So 304C19 it was prior to the cumulative impacts rules and was part of the mission change rulemaking. And there are a number of areas in the statement of basis and purpose. And one area in particular, and I'll give me a second to pull it up, but it does talk about the need to be able to evaluate reasonably foreseeable future development as part of that. And so happy to cite that here in a second once I pull it up, but I'm not reviewing this under the new cumulative impacts rules. I'm reviewing it under the mission change rules that do include 304C19 and the elements required to evaluate and address cumulative impacts. So
Yeah, no, I appreciate that, Commissioner Messner. And Commissioner Boudreau, I don't know if you or staff has any comments on that point. I just want to make sure we're all judging apples against apples.
No, that's all I had, Mr. Chair. I just wanted to make sure we're all operating under the same set of rules, not trying to constrain Commissioner Messner's deliberations or decisions.
Other commissioners with thoughts? Commissioner Oath?
Thanks. And actually, I guess I'll weigh in here with a comment or some comments on more of a discrete issue and somewhat building on this conversation of which rules apply. And also not in a position to provide the ultimate conclusory where am I comments or remarks. So just prefacing that, I want to share that I have significant concerns that the Duncan facility was largely constructed without a permit from this commission, and it was a significant amount of construction that occurred. That 34 acres of the flow line on top of additional surface disturbance done within high priority habitat. We have significant concerns raised by the adjacent county for these reasons. I'm puzzled that the applicant did not obtain a permit for this level of construction. Based on testimony, they obtained a permit from the county. They obtained other state permits prior to construction, and so it just suggests to me that either the operator was somehow unaware of the ECMC permitting requirements, which would be concerning and frankly kind of baffling, or that they decided to take a construct first and ask for forgiveness after approach, which is even more concerning. So given that this is the operators maybe perhaps first OGDP before this commission, and they're contemplating much more development. I have concerns that this kind of a history reflects on whether or not this operator has an inability to understand or has an unwillingness to follow our rules for operating an oil and gas facility in this state. So I've been reflecting on that and considering our rules, and this is where it comes back to, I guess, AAG Boudreau's comment. Rule 315B5C Roman numeral 11 instructs this commission when looking at a cumulative impact analysis that's submitted along with an OGDP to look at and consider the operator's compliance history. And to me, this could be a kind of situation as that's an example of what the rule is intended to have this commission consider. Does an operator's previous compliance or non-compliance history indicate that the operator is unable to comply with rules going forward? But unfortunately, this rule was not in effect at the time that this application was submitted. The application was submitted several months prior to the effective date of that particular provision, and I don't believe that there is a similar one under the rules that were in effect at the time. But if it had been, I guess that my comment is that I would be taking a very hard look at whether the compliance history by this operator would lead me to vote for a denial based on the significant concerns that I would have about an ability to operate in compliance with the rules going forward. But it is unfortunate that this rule was not in effect, and I don't believe that there is anything similar in the rules that were in effect.
Thank you for the comments. Further comments, deliberations from commissioners? Commissioner Ackerman.
Yes, I appreciate Commissioner Messner and Commissioner Oath leading off, and Commissioner Oath particularly expressed comments associated with my thought process over the time reviewing this application. I certainly was particularly skeptical due to the circumstances surrounding the non-compliance associated with and I mean, I don't want to kick too hard, but gross non-compliance, in my opinion, of not seeking out the proper approach to permitting prior to beginning construction. It is kind of compliance 101, and so it does cause me concerns associated with ongoing compliance. That said, the AOC was created, it was complied with, it has been effectively and rapidly dealt with. I do know that they've been working significantly with CPW in these sensitive areas since 2023, extensively and on a consistent basis, and that while the construction that took place was certainly out of compliance with permitting, it was in compliance with timing stipulations under the advice of CPW. And so there's a demonstration of some degree of intent to be compliant and work with government. But I also I'm trying to couch this in the way that I actually feel. I feel grumpy and cranky about this. I don't like the process by which this came to us, and it makes it very difficult to handle. That said, I believe that we're working towards being in a situation where I think it does comply with our regulations at the current time of its presentation. And so, I certainly had thought about talking about a short leash associated with any future noncompliance. I think Commissioner Oath did a really good job of expressing the way that I feel about that as well. So I don't see a significant noncompliance with regulations as they exist today. And that's what's kind of driving my thought process at this point.
Thank you, Commissioner Ackerman. My deliberative thoughts are, I think, similar to yours. And I also agree with you, Commissioner Oath, about the significant non-compliance or the gross non-compliance, as you called it, Commissioner Ackerman. However, and while that makes me grumpy too, they went through the enforcement process. We agreed to an AOC with a significant fine that was not suspended, and they paid it to the tune of 800 some odd $1,000. And part of that AOC also said, you need to get into compliance by filing for the permit that's before us today. So all of that jumbled together makes me grumpy and cranky too. I'm not sure I'm seeing non-compliance with regard to the application before us today. But I gotta say, I'm not inclined for the Duncan facility to become a centralized facility for, I mean, right now, he said one more OGDP would be a third of the way there. Well, that would be two OGDPs with a significant number of wells, and then they still got, what, three, four more to go? And it seems like that's their game. And if I vote yes today, that does not mean I'm voting yes for future things down the road. Now, if the applicant wants to voluntarily take this application, shelve it, do a comprehensive plan, look at all the impacts from all of the proposals, that might be a really nice thing to do, but we can't require them to do that. At least that's my understanding. A comprehensive area plan is volitional on the part of the applicant. So I guess where I'm coming down is I might get to a place of approving today's venture, but that's no signal from this commissioner that down the road, all these other planned things are going to be appropriate for Duncan and the flow lines and all that stuff. Commissioner Cross?
Thank you, Chair. And I also want to say thank you to everyone else for kind of leading this off. I say I like the grumpy term. I think perturbed was more what I was leaning towards in reviewing this. And Chair, I agree with a lot of your sentiment there, and I do, based on my understanding of the future plans, I love the idea of a cap. I also understand that given that this is a federal unit and there's certain unit obligations and timelines, that also adds another layer of difficulty in trying to get a cap set up and approved and still meeting those unit obligations. I really appreciate Commissioner Messner addressing a lot of the concerns with the 2B and some of the uncertainty with some of the plans even as put forth with this application. I admit I'm not 100% sure how I feel one way or another on this. I think that it's in a situation where, as said, this was part of the AOC, that they would get into compliance, that they would do this. They paid their fine. And so, yes, they're in compliance, but I also have serious concerns of moving forward. It's a little hard to say we'll be better in the future when we don't have that indication of trust to begin with. And it makes it really difficult for me to try and put faith in that. I do appreciate that they've been talking consistently with CPW, pre-application meetings with them on some of the future sites to try and make sure that they're getting things done and done correctly for future sites moving forward. It still harkens back to the fact that they haven't necessarily done that up to this point, and that's a little frustrating. I do also have concerns with kind of what's the best option now, even depending on what happens here. If we were to deny this, is the remedy for them to try and go back and do another ALA and refile this? Is it to remediate what's already been done? There's already some disturbance done as well, and that I think additionally puts us in a little bit of a difficult situation in how to handle this. I think ultimately, based on the CPW correspondence, despite the frustrations with what happened, the fact that waivers were eventually agreed to, I think is noteworthy, and having me lean towards saying potentially yes in this instance. But again, I think grumpy, perturbed is a good way to put this, and I'm not 100% sure how I feel about it.
All right, commissioners, I have an idea that hopefully you guys might get an agreement with. I don't like making decisions when we're grumpy. Why don't we continue this to our next available agenda, which I do not think is next Wednesday because I think three of us are gone. Give a chance for us to sort of think through our thoughts here without making a hard determination. Mr. McGee, that might give you and your clients an opportunity to think about all the things you've heard from commissioners as well, which might not be might be time well spent. But I see you visualize, so I will, before I throw out a motion, I'll let you speak if you desire to do so.
Thank you, Chair. And I understand the difficult position that this application puts it in, the kind of where this stands. However, PRM has demonstrated their compliance as best they can, given what they can in the AOC process. And I understand trust will be hard earned, but they need the opportunity to do that. And I think the approval of this application helps to build that. I think a concern we have with the continuance obviously would be with the timing stipulations that we're against, and understanding that those are partially driven by the application timing, but that is a concern PRM would have with the continuance. That said, we understand your position as well. But I think a lot of the points you made are issues that PRM really would like the opportunity to address. And we cannot do that without approval of this application to that point. So that's my twos.
All right. Well, thank you very much. You can unvisualize. Frankly, commissioners, I didn't find that to be all that helpful. Seeming like they are boxing us into trying to make a decision today when none of us feels very comfortable with that decision. But I'm looking around to see what others are deliberating in their minds. Commissioner Oath?
I will say I, for one, really like the idea of continuing it to allow us some additional time. And what I was hearing, what I feel myself and was hearing from other commissioners is still not being sure what they think is the appropriate outcome. And so I think giving ourselves some additional time to consider that would be very beneficial.
Commissioner Master?
Yeah, no, I appreciate the thought. I think that makes sense to me. I would just to make my thoughts clear here. I think what's being presented to us right now is really not the utilization of the Duncan facility as a central production facility, but rather a facility associated with one pad. If it truly is to be contemplated as a central production facility for multiple pads, multiple future OGDPs, then this application needs to get revised to reflect that both in the cumulative impacts plan and other associated plans. As per the rules require, as it does in our mission change rules, require contemplation for reasonably foreseeable future activities as well as past and present associated with information provided on the Form 2B, and the 304 C19 requires the utilization of the Form 2B to develop findings on how they've evaluated and addressed cumulative impacts. So this is all part of the mission change rulemaking and required elements of applications. And so that's just to provide some perspective to an applicant, in the interim here between now and whenever we may continue this too. I also think that there are opportunities, as Chair Robbins indicated, for evaluating the opportunity of a comprehensive area plan that would really be the best way to approach this. But can't require that, but just know that I think there's an opportunity here which may in the end benefit your local jurisdiction of Moffat County better than the approach that's being taken with piecemealing it, whereas they would know exactly what the big picture plans are and be able to look at how that may beneficially affect Moffat County more holistically and more certainly over a longer time frame. So, but anyway, long way of saying, Chair Robbins, I'm good with a continuance.
All right. Mr. McGee had mentioned something about timing steps. I kind of like to hear from staff about that. So is Ms. Waldron still available? Ms. Waldron, have you been listening in to our discussions?
Yep.
If we don't make a decision today, this pad is, or this production facility is constructed, what are the impacts of no decision today and maybe having a decision in a few weeks?
My understanding is that based off of the wildlife timing stipulations, that PRM, based on their submission of the Form 42 construction notice, that they're anxious to begin work on the pad expansion. I suspect that continuing this may delay any work on that location until until after winter, um, which then leaves the location unpermitted, disturbed, um, rolling into 3 years now.
Lovely. No, thank you. I appreciate the ability to sort of put a fine tooth on what is already a difficult problem. Commissioner Messmer?
Yeah, I'm struggling with that a little bit because we've got 2 weeks here that we're talking about continuance and the timing stip, even their information that they've provided in their presentation today indicated that there was 3 or 4 week buffer there that was contemplated in their construction timeline before the November 15th timing stipulation. So I have a hard time believing that a continuance today automatically kicks it into a spring construction season. So
Commissioner Ackerman?
Thanks, Mr. Chair. I'll just be very frank. What I had hoped for and expected today was for the operator to come before us and directly address the issue. I understand there is an AOC. I understand there is an enforcement issue. I expected them to come before us and essentially say, we can't believe this happened. Here's how it happened. Here's how we're going to avoid things like this happening in the future and proactively address it. The fact that they didn't do that caused me some concern about being able to be in compliance in the future proactively and directly addressing issues as they arise. And so I just wanted to make that clear and state that I, I don't know that it would be helpful at this point, but maybe we contemplate giving them an opportunity to talk a little more at the next hearing. I think maybe you were alluding to that as well, Mr. Chair. I think that might be somewhat helpful, but I also do not have an issue with the continuance as we continue to ponder, recognizing that at least from my perspective as one commissioner, I haven't seen this before. This is a unique situation to me where someone significantly begins construction on an operation prior to being permitted. And I do think, continued opportunities to ponder how we avoid situations like that in the future being pushed through due to potential timing constraints is an important topic to ponder.
Appreciate that, Commissioner Ackerman. I move to continue this matter to September 17th. Do we have a second?
Second.
Deliberations on that motion from me are operator and attorney. You've heard a lot from us. I would anticipate that you would be well served to try to address the commentary from commissioners on September 17th.
Understood.
Thank you, Mr. McGee. Any further discussion on the motion? Seeing none, all those in favor signify by saying aye. Aye. Any opposed? That motion carries. We'll put this one first on the agenda on September 17th at 9 a.m. Or as otherwise set up by Hearings Manager Thomas. All right, commissioners, it's 12:21. We've got to retake up the statutory alignment rulemaking. Let's maybe return at 1 o'clock for that. Does that sound good? All right, see everybody in just a bit. Final agenda item, and that is docket 250600119, the statutory alignment rulemaking. To sort of set the stage here, we did this rulemaking, was it just last week? And we provided some guidance to staff. Staff published a red line rule as well as red line statement on basis and purpose yesterday around noon. Commissioners have had a chance to review those suggested changes, and we are going to retake up the matter today. We're going to start with a presentation from Deputy Director Lauren Mercer-Gelman. We also have some information that will be provided to us via Assistant Attorney General Davenport. And then, Commissioners, we need to decide if we wanted to give API and KOGA a few minutes at their request, which we would take up after we hear from staff. At least that's my proposed procedural playlist. Ms. Mercer-Gelman, good afternoon.
Good afternoon, Chair Robbins and Commissioners. Are you ready for me to present?
Please.
Okay, great. I will share my screen here. And while I do, for the record, I am Deputy Director Lauren Mercer-Gelman, and I'm here to present on behalf of staff. Can you see my presentation? Good. So I'm here to provide an overview of the changes that staff made to the draft rules and the statement of basis and purpose following last week's rulemaking hearing. Staff prepared clean and redline versions of the revised rules and SBP by noon yesterday, as requested by the Commission. These were filed in the docket and emailed to the Commissioners and all parties, so hopefully everyone who needed to received them. In case you have questions for our subject matter experts or our lawyer, I'm joined by Adam Craich, Jeremy Farron, Steve Kirschner, and Sarah Rowlands again. Jumping right in, last Wednesday, the Commission requested that staff make the changes shown on this slide to the 100 series definitions and the 500 series enforcement provisions. Those were to delete the definition of compliance officer, to add language to the SBP, clarifying that the use of CDPHE's disproportionately impacted community mapping tool is optional. Those were the changes related to the 100 series. And then in enforcement changes, we revised Rule 525D to clarify that the Commission may consider any violation confirmed through an AOC or OFV. We changed the word determines to alleges into specific rules upon direction from the Commission and requests from parties. We added language to the statement of basis and purpose, clarifying the application of the continuing violations doctrine. And we also added language to the SBP, committing to explore Larimer County's suggestion for revisions to an aggravating factor at a later date. I don't intend to focus on these changes in my presentation as they're fairly straightforward, but of course I'll be happy to take Commissioner questions on any of them. The more substantive revisions arising from last Wednesday's hearing were related to worker certification. So you asked us to revise the rules to limit the requirement that workers be certified to only the statutory categories of workers listed in SB 181. We did that. You also asked us to adopt relevant exams in lieu of the F31 exam, which I believe is the topic that Mr. Davenport will be speaking on shortly. And finally, perhaps the most substantive revision was to make sure that we could allow welders working on flow lines to demonstrate compliance with the 7,000-hour training requirement from SB 181 through a combination of education and experience. With respect to the welder requirements, the Commission asked us to work with the industry trades, KOGA and API, and the Pipe Fitters Local 208 Union. We did that, and I'd like to thank those folks for working with us on the quick deadline that we had. In particular, I'd like to thank KOGA's counsel, Ms. Ryan, for staying in touch over the holiday weekend as staff continued to work out the language. I'm happy to report that both the trades and the pipe fitters support the language in staff's revised draft. I also note on this slide that there were two areas where once we started drafting, we realized we weren't sure that we had consensus from the Commission. I know we tried to clarify all of our to-do list at the end of the hearing, but inevitably there are some details that we didn't get to. So the first was whether there should be a delayed effective date for the welder requirements, which I believe was discussed in terms of a delayed effective date for the welder requirements writ large and or for the exam. We drafted it with a delayed effective date for all of those welder requirements for your input. And second, again, for welders, was whether there should be an exemption for welders already working in the oil and gas field. We included language on both of these points in the draft, anticipating that if it's not the commission's desire to include one or both of them, it's much easier to delete something from the draft than to craft new language during a hearing. So let's move into the requirements for welders. So this is the revised rule language related to the welder requirements. As you'll recall, there was a lot of discussion at last week's hearing regarding SB 181's requirement that welders working on flow lines have 7,000 hours of on-the-job training or work under the supervision of someone with that amount of training. Based on your deliberations and party input, you directed staff to build out this rule to describe how a combination of education and experience can be combined to satisfy that requirement. And you asked us to work on the trades with the trades on this, and Koga in particular was enormously helpful, including by bringing in the assistance of Mike Whitman, the owner of Whitman Consulting and an expert on welder qualifications, who, along with Koga's director and counsel, met with Mr. Craich and I to discuss a lot of this rule language that you see. So here are the changes that we made on the 7,000 hour piece. First, we explain in the SBP that by training in the 7,000 hour context, that can be met with a combination of actual work experience and more formal training, such as in a classroom. We also specify that the option to work under the supervision of someone with 7,000 hours of training doesn't require that the supervisor be looking over the shoulder of the welder for all 7,000 hours. Rather, they need to be directing the welder in a way that aligns with industry standards and practices, which is articulated in the SBP. Then we added Rule 602B4B, little I through little IV, to specify how one can get to the 7,000 hours of documented on-the-job training. Of course, one option that sort of goes unspoken here is that requirement can be satisfied exclusively through on-the-job training, just like the text of the statute and the rule says. However, little I through little III also allow certain levels of educational attainment to substitute for certain amounts of the 7,000 hours. That's broken down here. So a little over 2,000 hours for trade or vocational training, a little over 4,000 hours for an associate's degree, and all 7,000 hours with a bachelor's degree in welding. So these equivalencies are based on the standards used by the American Welding Society, or AWS. AWS is the organization that certifies welding inspectors. And that's a more stringent certification and requirement than what is established by SB 181. To be an AWS certified welding inspector, an individual needs a combination of 5 years or about 10,000 hours of experience, as opposed to SB 181's requirement of 7,000 hours, which is about 3.5 years. To be clear, we used AWS's equivalencies as a proxy for how much credit to give for the different education levels, but are not in any way saying, implying, or requiring that welders working on flow lines need to be certified as welding inspectors. That's something different and above and beyond what we're doing here. Rather, we use the same years of education to hours ratio to dial in the correct amount of credit. In particular, we gave significant consideration to 602B43, which states that a bachelor's degree or higher in welding can substitute for the entire 7,000 hour requirement. Our understanding is that it is somewhat rare for folks to obtain a bachelor's degree in welding. However, we do think this rigorous and specialized training should be recognized in the rules. And our standard understanding is that welding bachelor's degree programs include a significant amount of practical experience, such as lab work, co-op programs, and other on-the-job training. And because of that, we feel that a degree in this field would satisfy the SB 181 requirement of 7,000 hours of on-the-job training. Moving on to 602B4B4, we specify that up to 5,000 hours of the equivalency may be obtained through other work in oil and gas related positions. And staff believes that this is appropriate because if you have someone with 5,000 hours working as a roustabout in construction or in operations in the oil field, they may not have been welding during that time, but they'll have a deep understanding of flow lines, equipment, and the conditions that these systems face. And that knowledge makes them better prepared to weld safely and effectively in oil field environments because they understand both the weld itself and the real world demands they will be exposed to. So in staff's view, this other oil field experience is extremely valuable. Moving past the 7,000 hour requirement, 602B4C addresses the certification requirements for welders working on flow lines. So as discussed at last week's hearing, the F31 exam that's in statute in SB 181 does not apply to welders in the oil and gas industry or even to welders at all. The two tests listed here, API Standard 1104 and ASME Section 9, are the relevant standards for welders in the oil field. And you'll note here that API uses the term certification, while ASME uses qualification. We mirrored the terminology used by those organizations, but the two terms functionally mean the same thing. They're both a test that you have to study for and pass in order to be able to say that you are qualified or certified. This is my last slide, I promise. So Rule 602B5 would exempt welders who already have their API 1104 certification or ASME Section 9 qualification and at least 1 year of work experience prior to the effective date of the rule. Those folks would not have to demonstrate compliance with the 7,000 hour training requirement. Now, this provision is one of the ones I flagged for you at the outset of my discussion that I'm not sure whether you wanted staff to draft this rule. So we did for your consideration and can keep it, modify it, or strike it based on your direction. Now 602B6 is the mechanism for compliance. It specifies that compliance can be demonstrated by providing a sworn verification attesting to the necessary amount of experience. Now this is was something articulated by a commissioner last week, and it's intended to address concerns that were raised that welders may have, the required experience or even more, but might lack official records to demonstrate compliance. We were told by the commission that that should not be a barrier. So staff feels that a sworn statement paired with staff's ability, as always, to request and require additional information and support if needed, is an appropriate demonstration of compliance. Finally, 602B7 requires operators to provide training and certification records to the director upon request. This was largely existing in the previous draft, and we also revised the SBP to explain that the operator need not be the custodian of their contractors' records, so long as the operator can access and provide them to ECMC upon request. So with that, I can take down the screen share and I am happy to answer any questions the commission might have. And I'll remind you, I've got my rulemaking team here if there are questions that I can't answer.
Thank you very much, Mr. Mercer-Gilman. Really appreciate the hard work on behalf of staff over the Labor Day weekend and getting that to us today. I think it looks really well done and appreciate the additional work and particularly the worker certification piece. Um, Before we open questions to you, let me go ahead and recognize AG Davenport for his piece of this puzzle real quick, and then we'll open both of you up for questions.
All right. Apologies for that, everyone. My computer was being really slow there. Thank you, Mr. Chair. I would like to touch on a piece that is in addition to what Deputy Director Mercer-Gelman has discussed, and that is in relation to the certifications or qualifications associated with welders working on flow lines, and we're talking specifically about what is new draft rule 602B 4 C, where it discusses the tests that or exams that Deputy Director Mercer-Gelman already recognizes as the correct ones incorporated in the rule. And of course, I'm aware, as you are, and all parties to this, is the commission's decision in the course of its kind of preliminary deliberations that it would not be correct or appropriate based on the record that the F-31 exam is not the appropriate exam to include that in the draft rules as a requirement. However, in the interim between the commission's initial deliberations and today, I, in consultation with a few folks over in my office, identified a concern in regard to a legal concern in regard to not adopting that widely recognized inapplicable exam, given that the statute specifically directs that that be the exam that applies for welder certification. Our concern specifically was that as the statute requires that test, there may be a question about the commission's statutory authority to not include that test in rule regarding welder certification. And so we have come up with a solution to that issue, and that is to include the F-31 exam in regulation, but to delay just for that very specific portion the effective date of that requirement to a date that I can certainly suggest, but would be your choice should you choose to go this route. That would mean that if the commission adopts this solution on the effective date of these regulations, the API standard 1104 and ASME section 9 require qualifications or certifications would go into effect as with the other dates. But the effective date and therefore the requirement for the F-31 exam would be delayed to a future date certain stated in the regulation. I think, at least in my view, the record supports that delay in that, again, in my view, there was information in the record that many welders, if not all, working on oil and gas flow lines do not currently have that certification, the F-31 exam, as it is not applicable to the work that they do, and therefore it could take significant time for those welders to study for and be prepared to take and pass that exam. I'll pause here, Mr. Chair, right now. I do have I have drafted an addition to the draft rules that went out yesterday with staff's draft. I think everyone probably noted that the solution that I just proposed was not in that draft. So I'm happy to share my screen now.
Yeah,
to
why don't
show
you go ahead and
that.
share?
Okay.
Let's go ahead and share.
Just 1 second, please. I'm going to apologize in advance. I couldn't figure out a few of the formatting things. So just 1 second. My computer is being very slow today, and I apologize. All right. Hopefully you should now have on your screen what is some pretty large text, and I'm going to highlight something here showing the solution I proposed to the legal issue we recognized, and I've highlighted it. That would be, and of course, it's subject to the commission making changes. And I would also note that I don't believe that staff has yet seen this language. It's my language solely right now. And so, subject to staff providing thoughts and certainly the commission's decision, this is what I'm suggesting. The October 1, 2021, 2028 deadline is just a placeholder. If you think a different date is appropriate, then that would be what goes into these rules.
I appreciate the 3 year. I think that makes sense. Did you mean for this to be a Roman at D as opposed to a little 3?
I did mean it that way, Mr. Chair. And the reason being, it got a little weird in my drafting to just put an and after
Yeah.
analogous successor
Okay.
qualification, because that made it seem like.
So then, if that's the case, should it read effective October 1, 2028,
Excuse me,
comma, passage of the International Code
correct.
exam?
Yep.
That's really all I was looking at. Okay.
Oh, double the.
Okay. Commissioners, with that, we have both Ms. Mercer-Gelman as well as AG Davenport available for questions. Commissioner Oath?
Thank you. And thanks to everyone for all of the great work and quick work on this in the past week and over the long weekend. Really appreciate it and very well done. I have, I think, a question for each of you, though. So, AG Davenport, since you're up and your language is up and highlighted, I'll start there. I think this makes a lot of sense. I appreciate that you couch that the record supports a delayed effective date, given that it would be necessary for workers in the field to have some time to come into compliance with this requirement, given that it really is not applicable to their work. I think we also discussed that it could provide some time for a legislative amendment to occur to reflect what we believe to be the legislative intent. And so what I'm wondering is, in the event that that were to occur, that there is a legislative change between now and this effective date, that seems like, as written, it would require this commission to take further regulatory action and amend this to remove it. So I'm just trying to figure out, is there a way we can prevent that with something written in here, a sunset date, or unless there's a statutory change removing such and such provision. I don't know if that's possible, but just in terms of efficiency, wanted to explore that.
Thank you, Commissioner Oath. Perhaps, yes, there is a way we could potentially cite the specific statutory provision, which is 3460-106 20D Roman 3 in this case. Citation to the statute, if the statute changed, could potentially give us the ability to, depending on the change to the statute, could potentially give us the ability to avoid having to make a regulatory change here. I can't take credit for that idea. I have to give credit to AG Rowlands for that one. But that citing the statute in the language that's highlighted on your screen right now could, again, depending on the specific statutory change, make it unnecessary to have a special rulemaking or a special part of a rulemaking to amend this regulation.
Okay. Yeah, I just think, I mean, if we could, that, and it makes sense. Go ahead.
I was just going to suggest AG Davenport, once we're done with questions, we might take a little additional testimony. If you and AG Roland could work on that language and bring it back to us, I think that would be helpful. I think that's a really wise idea. And thank everyone for thinking about that.
Happy to.
Commissioner Messner, on this topic.
Just on the finite topic, sorry, Commissioner
Yeah.
Oates. Just FYI, that if we cite the statute, then that statute, which is SB 19181, would have to go in front of the legislature for modification. And so I don't know, there's some challenges associated with that as well.
I don't know that I follow that, Commissioner Messner. That sounds awful.
Well, the worker certification that includes F31 was part of SB 19181. And so
Right.
if we cite that, and correct me if I'm wrong, but if we cite that statute and it was SB 19181 that created that statute, does that mean that SB 19181 itself needs to get modified, or is it just new legislation that would address that
I
statute?
think it's just like right now, the 181 amended something in Title 34. And I think if we just cite that Title 34 specific provision, and then that is later amended through whatever legislative fix happens, I think that's, and this is, I'm talking out of school, so I don't really know. AG Davenport, do you have thoughts on this?
It would be the latter of what you just discussed, Commissioner Messner. We are not required to, when a bill amends a statute, to also amend the bill when we go back and change whatever. If we go back and the legislature goes back and changes whatever statutory provision was amended by that bill, all we need to do is all the legislature needs to do, excuse me, is to amend that provision of the statute. So I do not believe that it would require us to also go back and have the legislature or attempt to get the legislature to change Senate Bill 181 as well. Just change the statute.
All right, then never mind.
All right. So we've given direction to AG Davenport and Roland to massage this language just a bit. We still have Ms. Mercer-Gelman and AG Davenport open for questions. Does anyone have questions? Commissioner Oath.
Thanks. My next question is for Ms. Mercer-Gelman, and it is, I think, just a clarification component in, sorry, what's the underlying one? 602B4B, and in the four components that are now listed out. And thank you for the work on that again. In some places, in the 1, 2, 3, and 4. It makes sense. So, for example, in 2 and 3, it says, a degree in such and such may substitute for an X number of hours. And then in sub 4, it talks about, work hours can substitute up to. And so it's sort of correlated with the number of hours that were spent performing that action would be equivalent to the number of hours. So I just want to make sure in little I1, if it should be an up to 2,080 hours. So I'm just trying to understand that the trade or vocational courses, so completion of trade or vocational courses, is it intended to be that completion of any trade or vocational course substitutes for exactly 2,080 hours, or would it be an up to depending on the course that is taken and completed?
So it would be our intention, in alignment with the American Welding Society, was for each course could account for up to 2,080 hours. So if you took multiple trade courses, you could get additional hours.
So each course is kind of already has an approved, in order to be approved or whatnot, has a certain amount of rigor to it, such that we feel that it's appropriate for each of them to substitute for 2,080 hours. Is that what I'm understanding?
Yes, though I may phone a friend here and ask Mr. Crate to visualize himself and correct me if I'm wrong there.
Okay.
There we go.
I don't know why I was taking so long. But yeah, no, that's exactly right. There's really no standard of the courses you're going to take, to get those certifications or those um, degrees, for lack of a better term. So they're all going to vary. I would imagine very greatly by different schools and different programs. So this kind of is built in to solve for that uh, mystery around how, to kind of accommodate all those different programs that might work in unison to get those hours.
I see. So rather than course by course tracking the number of hours that would be added up and count, it's sort of saying in general, on average, the courses amount to around 2,000 hours.
Correct.
Okay. Okay. Thanks. I appreciate it.
Further questions for the panel, Commissioner Messmer?
Thanks. Just on that one, while Mr. Case is still here. So is it does does the course itself take 2,000 hours, which is, I mean, that can't be right. It's just, it could be a 2-week course, but it counts for 2,000 hours, right? Is that what I'm understanding?
Yeah, but you'll end up doing some field work in those courses as well. So you may or may not get some credit on some of those courseworks because they're going to be external. Many of them are co-op, right? So you'll essentially in those courses, you're going to do X amount of classroom work, right? Basically understanding the chemistry of the chemicals that you're working with or the gases that you're working with. And then a significant amount of that's going to be what I would what we termed lab work, but it's actually going to be shop work. And then many of those programs are co-ops with like a local businesses, local welding businesses that are going to, in effect, put you to work. And that's where kind of the hours vary, and that's where you're going to get majority of those hours is doing the actual co-op work that's really required for those certificates.
Okay. My other question has to do with 602B4B4. And that one, which states documented work hours performed in oil and gas related positions may be applied as credit. So I guess I'm a little worried about the vagueness of oil and gas related positions. I could argue that I've got work hours performed in oil and gas related positions in my job right now, and I certainly would not want to be certified as a welder. And so I wonder if we could put a little finer point on that and talk about directly related to flow lines or pipelines or something like that to, not make it allowed that someone who's a communications director in an oil and gas company could qualify for that. Not that, I mean, I'm looking at loopholes here, right? But I'm not that I think that would happen, right? But there's no language in the SBP that clarifies it, and so somewhere it's got to be clarified that it would have to be, directly related to flow lines and pipelines.
Thank you, Commissioner Messner. I think that's a really excellent point that I hadn't thought of. I also have a lot of work hours in an oil and gas related job and have no business welding. So I think that's a great point and something that we could clarify in the SBP. I will again ask Mr. Craich to weigh in on whether it should be, or staff's point of view on whether it should be limited to just work really closely related to flow lines or more broadly field work. From some of our discussions, I believe he's expressed that there could be benefit and relevance to jobs when you're out in the field that go beyond just flow line related work. But I don't want to put words in your mouth, Adam, if you could jump in here.
Yeah, no problem. I think a great way to kind of summarize what Commissioner Messner is trying to get at would be just operations. How basically say, okay, the work hours would account towards your welder certification as long as they are in actual operations, all right, not administration or um, you know, otherwise, like, there's some other jobs out there that would be not relevant, that would still be field work, like, vegetation reclamation, stuff like that, that might not be relevant as well. But operations, I think, would specifically um, zero in on understanding basically the process flow, because that's really what we're talking about when we're talking about flow lines is process flow. So operations, I think, would be a good placeholder for that.
Yeah, I'm okay with that. And any flavor on this conversation, like what you're talking about, Mr. Crash, in the statement of basis and purpose, I think makes sense as well, right? But I know that this is very much towards the end, and so we're talking about changing some words right now, so I'm okay with operations. Um, so yeah, that's the only question I had.
Further questions for the panel? All right, thank you very much. I'm seeing no further questions. Hearings Manager Thomas, are you with us?
I am, Mr. Chair.
Just real quick, process-wise, I believe that I saw that API Koga requested a few minutes. Is that accurate, number one?
That is
And
accurate, yes.
and did any other party ask for additional time?
No, no other party has asked for additional time.
All right. Commissioners, I'm inclined to allow Ms. Ryan to come back. I assume it's Ms. Ryan, or maybe it's Mr. Martin, to speak to us. Seeing no one with concerns about that, let's elevate either Ms. Ryan or Mr. Martin.
Both Ms. Ryan and Mr. Martin asked to be elevated, so we will bring them both up.
Let's bring them both up. Good afternoon, Ms. Ryan.
Good afternoon. Thank you very much for allowing industry some time to comment on the rules that will affect it. My name is Julia Ryan, and I'm with the law firm of Brownstein Hyatt Farber Schreck on behalf of the Colorado Oil and Gas Association. To begin, I must credit your staff for their swiftness in updating the rules in less than 1 week's time, particularly with the intervening holiday, and Kogo applauds their industrious efforts. Koga believes staff got many things right, including that Koga supports the rules as staff presented them, including grandfathering in existing workers and a delayed effective date. There are a few outstanding issues that the revised SBP and revised rules leave open, and the discussion regarding the F-31 exam is disappointing but extremely important. If you do adopt the F-31 exam, and notwithstanding AAG Davenport's remarks, I don't think you need to. I don't think that conclusion is one that is compelled. It could be quite cataclysmic for the oil and gas industry, quite frankly, if you don't have an effective date many, many years out. I would suggest further than what was proposed. That probably smacks of hyperbole, but I'm going to explain why. If anything, I think that's putting it lightly. If you'll permit me, by your leave, 10 minutes or less, I will focus on the F-31 issues, but there are a few other issues in the SBP that I would love to walk through, taking up less than 10 minutes of your time. That's all right. Okay. So one issue that we spent a fair amount of time discussing last week was the CDPHE DI community map, which in staff's revised SPP is now optional. So the guidance for this tool that came out just last month in August says that operators will use the CDPHE DI mapping tool. So the guidance will need to be updated. But in updating the guidance, the question becomes what may be used, could be used, should be used instead of the DI map. We need to make sure that staff and operators are on the same page. We also need some sort of confirmation that it's the DI status at the time of application submittal. So Koga understands that the statutory definition should be used, but what tool will be used to determine what satisfies the statutory definition by making the map optional. It's unclear what universe of information is going to be considered. And we think without clarity and without staff and operators looking at the same thing, this could lead to inefficiency and unnecessary conflict. We need a consistent tool. COGA continues to believe ECMC could adopt the most recent DI map through a rulemaking, that would be the proper avenue, and then subsequent rulemakings would be required for any further map changes, much like the commission updates its HPH maps yearly. Would it be possible for me to share my screen for the next few quick points?
Yes.
Great, thank you. Sure. Okay. So this is the staff's clean SBP. Just a couple cleanup things here. First, when talking about the consideration of past adjudicated violations, this is staff's new language that there will be a consideration of age and relevance when determining what weight to give past violations. I think COGA believes for consistency, you could add, if any, just to clarify that due to the age or relevance, some past violations may not warrant any weight. On page 7, here, this is new language from staff talking about what the commission intends by the use of the word compliance officer, a small nit, but to carry on through consistency and even to make it consistent with the very next sentence, COGA would ask that this or individuals language be added, just to clarify that it's contemplated that your compliance officers may be more than one individual. On page 8, so as presented, the commission understands that welding programs contain significant practical experience. Staff's language implies it's only bachelor degree programs that have practicums, but any college coursework or vocational trade work will have these practicums. And so we just want to make sure that it's not suggested that only the bachelor's degree programs have these hands-on issues. Okay, and then getting to the F31 issue. So staff had added this language here. I don't know if you can see my cursor, but explaining that staff believe, well, staff as in the commission, in this case, under your direction, that the F31 exam was a mistake. I think we're all in alignment there. No one believes it actually applies. So I want to address the conversation that not complying with the letter of the law would be unlawful. COGA strenuously disagrees with that position. Even adamant textualists recognize that sometimes the plain language is just wrong. And because of that, there are doctrines such as the doctrine against absurdity or Scrivener's error doctrine that's even invaded colloquial speech. Everyone knows that sometimes you fat finger a 4 when you mean it 5, something like that. And courts hold that when applying the literal interpretation of a statute would lead to an absurd result, it should not be followed. So COGA would suggest that the SBP and the commission consider not adopting the F31 exam, but shore up the conclusion of why it does comply with statute, because in this instance, applying the literal interpretation would result in an absurdity, which case law does not countenance. So, and there can be more if this could be supplemented. I mean, it's, as we discussed, the relevant to heating and ventilating system, HVAC, it would truly be an absurd result. I'm going to stop my screen. And then, should you disagree and you do include the F31, which again, COGA does not think is necessarily a mandated conclusion. We firmly think the effective date needs to be years out. We don't know when or if the legislature will fix the issue. Quite frankly, with all of the budget issues and other pressing demands, this is not the highest and best use of the legislature's time. And opening up the Oil and Gas Act after years of tumultuous change is unlikely to be helpful. So instead of forcing the legislature's hand to even act by 2028, we think it'd be appropriate, and the record supports a compliance date even out further, for example, October 1st, 2030. And quite frankly, if the compliance date is not several years out, it may result in a de facto ban on new oil and gas development in Colorado because there are simply not oil and gas welders who have passed the F-31 exam or could reasonably be expected to pass that exam even in a few years. Because quite frankly, it just doesn't make sense. If a welder did take the F-31 exam, why would that individual work in welding and oil and gas? Why wouldn't they then say, oh, I'm going to take this different education and work on HVAC systems? It just doesn't make sense for an individual to invest time and money in learning about HVAC systems only to pivot to the oil and gas industry. And if and it also, I think we're going to see this drain of jobs because why wouldn't you go and weld in a state that doesn't require the F-31 exam? Or again, if you take it, why would you enter oil and gas at all? So a ban on new development is not always also, or not only just an outrageous outcome that's not in line with the statutory intent, but COGA believes it would also be an unconstitutional outcome for operators, and it'd be an unconstitutional outcome because under Colorado law, an operator with approved permits has rights that may be vested if the operator has acted in good faith reliance upon that approval. And here, in almost every case, you can imagine a fact pattern where the operator will have acted in reliance upon, say, an OGDP to secure third-party contracts, vendors, materials, and so on. And once a right is vested, it may not be legally impaired by a law that retrospectively limits or restricts that right. Importantly, here too, for the oil and gas context, under vested rights law, an operator can have vested rights and approved permit even if a further permit is necessary. So, for example, the granting of an OGDP can be sufficient to confer upon an operator vested rights, even if there is no Form 2. And just a couple years ago in Aurora Public Schools versus AS and BS, the Colorado Supreme Court did confirm that there is no public policy exception to whether a law retrospectively impaired vested rights. The plaintiffs in that case had argued that impairment of vested right must be balanced against public health and safety concerns and the state's police powers to regulate certain practices. The court rejected this effort and said, we have never relied on public policy to salvage an otherwise unconstitutional respective law. And they clarified that there is no public policy exception under the Colorado Constitution. So COGA urges the commission give critical thought to applying an absurd statutory interpretation that could have such devastating consequences for industry, including indirect workers like full-line welders, who I will remind the commission often come from disproportionately impacted communities. I appreciate staff's concern, but COGA does not share it because of the well-established doctrine against absurdity. However, should you adopt the F-31 exam for the reasons I just mentioned, including the serious consequences for operators, because there are not people who have that qualification, and they're unlikely to be people that have that qualification, even if there's time to do it, because it's why would you do it? So for those reasons, I would suggest the effective date be out even further than the October 1, 2028 proposed. That's a placeholder by AAG Davenport, and ask you consider a 2030 date, if not longer. So in conclusion, COGA respectfully requests you make the changes I just outlined, and I respectfully request in my personal capacity that Commissioner Messner show us his puppy really fast. Okay, thank you for your time.
Okay. Mr. Martin, did you have anything to add?
Some very brief remarks. Excuse me, Chair Robbins. I wanted to say two things. One, as Ms. Ryan said, we really appreciate the work of staff over the holiday weekend. I was sitting in my office, unfortunately, as well on Labor Day, and I saw the interchange of emails between Ms. Mercer-Gilman and Ms. Ryan, and I was both impressed and saddened that we had to do that, but I really do appreciate the work they put in over a holiday weekend. And I think that the staff did excellent work, as Ms. Ryan mentioned as well. With respect to F-31, I'm going to do something I had never done before and hope never to do again, which is to disagree strenuously with AG Davenport. I agree with Ms. Ryan that you are not required by law to adopt a provision that by its result would lead to an absurd result. And I believe that's the case here. And in particular, I want to remind the commission that if you adopt AG Davenport's language and the legislature does not, by whatever the effective date is, passage of the F-31 exam will qualify someone to do something they're not qualified to do. HVAC typically doesn't even involve welding. It involves screwed on pipes. So as Ms. Ryan said, we don't want and not only don't need, but don't want people who qualified under F-31 in the oil field. It's not in the public interest. Beyond that, Mr. Chair, you're probably the only person who spent more time with the legislature than I, and I got to say that asking the legislature to spend its time fixing a small error like this in a matter that's directly related to Senate Bill 181 is an enormous task. It sounds like something that's easily done. It's an enormous task because it's tied up in oil and gas. So whether you can get this done by whatever the effective date is, and I don't plan to be around by then, but if whoever's left to do this work has to do that by that effective date, that is a substantial undertaking. Anything is a substantial undertaking at the General Assembly, particularly as Ms. Ryan said, there are significant budget and policy issues before the legislature. So one last importuning to adopt the staff approach and to ask and to reject the approaches being offered by AG Davenport, recognizing that might be a career-ending exercise for me. But that's the sum and total of my comments. Thank you, Mr. Chair.
All right. Thank you both, Ms. Ryan and Mr. Martin. I mean, kind of like the OGDP this morning, I feel the commission is being boxed into a dilemma of it's not its making. If we go back and think about the rulemaking that we've had today, we had zero testimony regarding how F-31 got into the statute. I was around throughout the creation of 181 into the details of the nights, and I can't recall, and I was very involved in 181. So I don't know that we've got a great legislative record that it was a clerical error or an absurdity, et cetera. Having said that, I agree that F-31 is not applicable to flow line welders. From the testimony we've received, that is indeed a true statement. I think we find ourselves in this place a little bit because of something that none of you have spoken to, but I'm going to call it, and that is the Attorney General's office has to do an opinion as to the efficacy of anything we do. Like, was it within our statutory? And that's where the flag was raised about not referencing in some fashion F-31. I, as one commissioner, would rather not reference it. But I also don't know what the import of not referencing it is versus the import of referencing it in this fashion with an effective date of 2028 or 2030. And I don't like either one of them. So there, I've called it out. AG Davenport, you can spank me, but help us out here.
Thanks, Chair. I just popped up because I heard AG's office. I had no intention of chastising or otherwise anyone in this case. I'm happy to provide a little more detail on the post-adoption process if you think that would be helpful and sort of how this issue arose.
I think it would. Let's
Okay.
go then.
Yeah, happy to do it. And I'm not speaking specifically as I talk about this process to ECMC. It's a process for all state agencies, as provided in the APA, the post-adoption rulemaking process. After a state agency adopts a rule, the Attorney General's office conducts and prepares what's called an Attorney General opinion on the rules, with the intent being, and the purpose of that opinion is to be a review of whether or not the rules the agency adopted are within that agency's statutory authority, or whether they conflict with any other statute or constitutional provision. Essentially a review of the legality of the adopted rules. And that's part of my job. It's part of any attorney in my office who represents a state agency. It's part of their job in rulemaking, is to ensure that the rules that are adopted are within our client agency's statutory authority. And certainly that's a primary goal, but one of the sort of sub goals is to ensure that we don't ultimately have to write an AG opinion that the rules are not within our client agency's statutory authority. And that's how this issue came about. I am not the only person in my office who reviews or approves AG rule opinions. They go through multiple layers of review. And in consultation with people in my office, the fact that the statute in this case specifically directs the commission to the F-31 exam was raised as a concern that would have to be mentioned in an AG opinion. And then subsequent layers of review at the Office of Legislative Legal Services and the legislature itself, that AG opinion could be a red flag that would cause post-adoption issues with these rules. And that's why we reached the conclusion that including the F-31 exam with a delayed effective date that would not raise concerns in regard to an opinion or the Office of Legislative Legal Services was the most conservative route, and the route that we believed would not cause post-adoption issues.
Having heard from the other two lawyers in the room, I know it's not necessarily your opinion, but it's folks within your office's opinion. Had they considered the absurdity case line?
We considered a variety of options. Ultimately, this was a solution or a resolution that we reached because there are many cooks in this particular kitchen, in deciding whether or not to raise a red flag in regard to rules that an agency adopts. And not all of those people are within the AG's office. And so while I do not necessarily disagree that there may be applicable case law here in regard to absurdity of results, I'm not the only person that has to be convinced here.
Sure. Yeah.
We still felt that the most conservative approach was the approach that I suggested.
And let me ask a final question, then I'll open it up. Commissioner Messer, I know you've got some questions. So we go down Route A, which is we reference it with an effective date 2030, whatever. And that gives the legislature the opportunity to make a fix. That's option A. We go down option B and include the Ryan Koga language that speaks to absurdity, and we don't reference it. Do you have any crystal ball as to what opportunities that gives? I mean, it seems like both might give the legislature the opportunity to fix it.
That's a question to me, Mr. Chair. I apologize.
I don't know. It's a question to the room.
Well, I obviously I don't have a crystal ball. I do want to raise one point. So, credit to AG Rollins again for her idea, referencing the statute and simply providing, as I inartfully drafted the initial language, but just saying effective, let's say October 1, 2030, the exam identified in subsection 3460-106-20D3, if the legislature changes that, we wouldn't have to go back and fix our rules. It would presumably still require a legislative change, but I think that would reduce the burden on this agency. But again, not having a crystal ball, this is the resolution that I suggested is the most conservative approach and the one that, in my view, has the lowest likelihood of the subsequent layers of review raising a red flag with the
But
adopted rules.
again, not to put a fine tooth on it, but the subsequent layers of review are with legislative legal services who, if they disagree with the absurdity piece, would go to the Senate president and the House and say, y'all need to fix this, right? I mean, that's what would happen.
Correct. We would end up, my understanding of the process, and I haven't been through the process before, but my understanding of the process is we would ultimately need to potentially appear in front of the legislature to defend the rules as adopted. And the ultimate result, one possible outcome is the legislature wouldn't agree, and some or all of the rules the commission is considering today and may ultimately adopt would be invalidated, which would require another rulemaking.
Well, I
Yeah.
can't imagine that they would invalidate all the rules based upon one absurdity reference, but I can't crystal ball it either. Commissioner Oath, you've unmuted. It looks like you wanted to say something.
Yeah, for what it's worth, I have been through the process and I was going to just chime in when AAGDF report was not sure, but that was my experience as well. Basically, the rule ends up on a list that goes into a bill that is like the rule review bill for the year that essentially says the following rules are ineffective as of X date, but then it goes through the legislative process to get amended. And if you are able to get your rule off of that list, which is largely impossible, then you've been successful. Otherwise, your rule becomes invalidated when that bill passes. But I would agree it's hard to predict whether or not it would be just this provision or the rules as a whole.
Well, I'm happy to go testify as to why it is that, if anything, it's just this one piece. But all right, we've got another lawyer with a hand up. That's Miss Ryan. And then I know Mr. Commissioner Messner had a question.
Thank you very much, Chair Robbins. I just want to say that in evaluating the two options, it's true that if you have an effective date, it may be down the road, but it is 100% certain the legislature will have to do something. With the second option, where it's only a problem if that red flag is raised and if those many cooks in the kitchen take that path, which I completely understand could happen. That very well could happen. But also, you've heard the testimony. I think all of us on the screen today are in agreement it doesn't apply. I think it gives, it kind of discredits, quite frankly, what Office of Legislative and Legal Services might do and what the AG's office might do, because I don't see how applying an exam that everyone agrees is inapplicable on its face helps, how that advances public policy. The AG opinion could cite any number of cases applying the absurdity doctrine. That's why it exists. And again, I don't have any control over that either, but I think we shouldn't take it as a foregone conclusion that the opinion would say it doesn't follow statute. I think there is ample case law precedent for an AG opinion to say something like, well, while it superficially doesn't appear to meet the letter of the law, the exam was found to be blah, 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 related to HVAC. Commissioner Robbins testified that he was very involved in the bill being promulgated, and he wasn't aware of, any reason why they wanted HVAC included. I mean, sure, there's a gap in the record, but the gap in the record works both ways. And since the exam on its face isn't applicable to flow lines, I just think that reasonable bright minds, I would hope, would agree that it is absurd. So thank you for letting me make that comment.
Very good. Commissioner Messner, you'd raised your hand a while back.
Yeah, a couple of questions. AG Davenport well, and maybe Commissioner O, since you've gone through this process, it's either like a yay or nay. So the legislature can't say, "Oh, we're gonna fix the rules for you," and then they're done. It either they throw out the rules or not. Is that what I'm hearing?
For my part, I would say through the rule review bill process, that is correct. Or there would need to be a separate bill run to fix the statute.
Right. So, yeah. Then my second question is, I was on the outskirts when SB 19181 was happening as a county commissioner, but my understanding is that the pipe fitters union was the one that developed this language. Do we have an opinion from the pipe fitters union that this is in fact um, an absurd uh, application of a certification?
Deputy Director Lauren Mercer Gilman, I believe you had a further inquiry with the pipe fitters union, and if you could testify to that, that would be helpful.
Yes, thank you, Commissioner Messner and Chair Robbins. So we do have confirmation from the pipe fitters that they submitted a public comment letter prior to the initial rulemaking hearing, stating that the F-31 exam is not applicable to welders working on flow lines and not applicable to welders in the oil and gas field, period. That is in the record. I also followed up with a representative of the Pipe Fitters Union this past Friday, I believe it was, regarding our revised language that replaced the F-31 with the correct API and ASME standards, and they agreed with that language change.
And so, in saying that, they agree that a reference to F-31 is not appropriate.
That's correct. That's what was represented in their letter and communications.
So I guess understanding that, and this is just me, and well, I'll wait until you're ready for deliberations to give thoughts on it. So, I
All
don't
right. Any further questions of the panel here? All right. Well, I believe that the debate amongst all the lawyers is concluded. We'll now turn it back to deliberations. AG Davenport, why don't you stick around? I was on deliberations. I'll just take a first crack at it. I had heard about the proposed solution of referencing it and then doing an effective date later down the road. And I think I was comfortable with it, but having heard from API and Koga this morning and having thought through the two options, I think at the end of the day, I like the SBP language that it's an absurd concept to reference an exam that is wholly inapplicable to welders in flow lines in the oil and gas field. And we should note that the pipe fitters agree with that and that there's no disagreement amongst the commissioners in making that finding. And then I kind of like rolling the dice on having a conflicting AAG rule letter versus putting something in that potentially, may create a hiccup, even if it's, further down the road. I mean, it's absurd. I love the fact that we're using the word absurd in a ECMC rulemaking. So I think that's where I land on that topic. And maybe we can just vet through this one specific topic and then we can talk about the other stuff. I really like all the other stuff. I think our staff did a phenomenal job. But anyone wanting to deliberate more on the F-31 issue? Commissioner Messner?
Yeah, I think I'm landing there as well. I think initially I thought having it delayed made sense, but I do think that this is a clear enough argument um, of inapplicability of a certification, and I think the legislative leadership has enough common sense and critical thinking to understand why we did what we did, and so I think I'm good with that. So
Appreciate that. Commissioner Cross?
Thank you, Chair. And I'll provide a little bit more color. Ultimately, I agree. I think it's more appropriate to roll the dice here. That said, I do want to point out a couple of the concerns I have. And I brought it up last week when we talked about this in the rulemaking, but I think we are in a difficult position here. And I think it harkens back to the produced water rulemaking where we talked about the centralized EMP waste facilities and the prohibition on the new facilities. And it's not that I was against the arguments made by some of the industry members on the West Slope about the problems with it, but it's also specific information provided in the statute. And as an agency, we're required to do what our mandating statutory language requires us to. And I'll admit I struggle a little bit here. And part of the reason that I struggle here is, Ms. Ryan brought up a couple points, unconstitutionality because of the potential impairment to a permit. I think that's a stretch because it doesn't actually impair the permit itself. When you see a lot of arguments with the impairment of a permit or impairment of some kind of right, it's something that specifically doesn't allow that to happen. So if there was something that said you can't drill, but you have a permit to drill, that would be an impairment of the permit, not making it difficult to hire somebody to work on the flow line. Similarly, I think my concern with the absurd results doctrine is, the classic example that's given in law school was always an old law that said you couldn't take blood in the streets, but at the same time, it would be an absurd result to say that if somebody needed to have emergency surgery on the street, they couldn't do it because there would be blood on the street. That was the example always provided. And that's the kind of absurd result that's usually referenced, not something of here's a test that's related to welding, granted not the welding of the type that we're talking about here, but it's a welding test used in another area, and they're requiring this welding test for welders. And so I think trying to say that it's going to be a certain absurd results doctrine case is difficult. That said, especially given that we have on the record information from the pipe fitters who proposed the language in SB 19181 about the requirements and that they don't believe that this is applicable, I think it's better to roll the dice in this situation. But I'll admit this
Which dice, Commissioner Cross?
To try and say like let's not have the F1 or F31 test in here and try and say if it has to come before, if it doesn't make it through OLS and it has to come before the legislature, we can defend it. Especially given the pipe fitters who proposed the language saying this is for HVAC, this isn't for oil field welding work.
Yeah.
I think that helps the case more so than trying to apply the absurd results doctrine or constitutionality. But I do find that this is difficult, given that it is specific language that is provided in the statute. And I think that's one of the things that kind of for everybody moving forward as we get some of these statutes, I think it's important to have testimony in front of the legislature about some of these different issues. And obviously, in the final moments of 181, having something like this kind of be run to ground, it was difficult. But I do want to make sure that everyone's aware that sometimes this is stuff that we need to make sure that we consider as people testify on legislation moving forward too.
Commissioner Cross, appreciate that. I do want to clarify. My understanding of F31 and AAG Davenport or Deputy Director Mercer Gelman, can weigh in. My understanding is the testimony was that F-31 has nothing to do with welding whatsoever. Like it was something totally different, which does create more of an absurdity in my mind. Ms. Mercer-Gelman, could you weigh in on that, or Commissioner Ackerman, if you recall?
Thanks, Mr. Chair. I wonder, unless the AGs are prepared to respond right now, I think that my deliberative comments might add a little bit to that question, if I might interject.
Go for it. But before we go there, Ms. Mercer-Gelman, did you have a factual understanding of F-31 that you could provide?
Yes, it is not related to welding at all.
Okay, thanks. Okay, Commissioner Ackerman, please go ahead.
Thanks. That might clear it up. Uh, I, on the F-31 issue, I think, the specter of the Scrivener's error was raised. I think that's very doubtfully applicable. I think F-31's required in other statutes, but the absurdity doctrine, is worth discussing. Black's Law Dictionary, absurdity refers to something that's irrational, unnatural, or so inconvenient that it could not have been intended by people of ordinary intelligence and discretion. If you go to ICC's website, the scope of the F-31 test tests a candidate's ability, this is verbatim, tests a candidate's ability to assist in the installation of heating and cooling equipment for residential and commercial operations in accordance with the adopted codes and standards, period. Which would certainly substantiate a lot of the claims that have been made here. As you dig further into the exam, there are some key aspects of that exam that could be applicable to commercial steelwork and welding. A couple of those examples that I extracted were: the exam is intended for individuals seeking journeyman level certification in mechanical trades, such as HVAC technicians, mechanical contractors, or other professionals working with mechanical and fuel gas systems. There's a section on code comprehension about understanding and applying prescriptive and performance-based requirements to mechanical and fuel gas systems. It also includes questions on code navigation, interpretation, and application, such as identifying relevant code sections, understanding terminology, and solving code-specific problems. And there's a section specific to gas piping system design, materials, and installation. So admittedly, there are some issues in there that could, in a roundabout way, certainly apply to commercial oil, steel, and welding work. They are, though, all under the header of the scope of the exam, which is to assist in the installation of heating and cooling equipment for residential and commercial applications in accordance with adopted codes and standards. And so I guess the absurdity discussion is difficult for me because there are some standards in there under which, absent better opportunities, maybe a reasonable person would think, hey, we want some type of certification, and there are, certain things that maybe apply in some fashion. That said, I agree that that's a stretch, and that it's clear that there are other exams that are more appropriate to the field that we're talking about here. Absurdity is intentionally a very high bar, like Commissioner Cross pointed out. It's very difficult, absent more info on the legislative history, to say that this was not intended by people of ordinary intelligence and discretion. That said, it seems very clear through testimony given here that it's an erroneous test. I appreciated Mr. Martin's thoughts on this could eventually lead us down a road in which we have people getting certifications that actually disqualify them rather than qualify them for specific work to be done in the oil field. I thought that was a poignant comment. That said, I'm kind of where Commissioner Cross is. I'm a little tough on the absurdity doctrine compliance here, but I also think that rolling the dice on that issue, as put by Commissioner Cross, is probably the right thing to do.
Thank you, Commissioner Ackerman. As a non-lawyer, you just out-lawyered several lawyers that have already testified today, so I appreciate that. Commissioner Oath, who is a lawyer, I would know.
Recovering one. I agree with the comments that this is really a tough spot. Particularly, I hope it's very clear to all that all any of us are trying to do here is carry out the legislative intent. So no matter what we decide to do, that is the goal here. That said, in my experience, I will say that going through the OLS review process and ultimately if you do end up on the rule review bill, it can be an arduous process, and it can sometimes have outcomes that make you scratch your head. And I mean that with all due respect to everyone involved in that process because they have a job to do, and that is what they're carrying out their job. But it can be challenging. So I commend AG Davenport for advising us the way that he did to try to keep us out of that and try to help us avoid that. The other thing I'm contemplating here is this question of if, worst case scenario, if we roll the dice and we end up on the rule review bill, what does that look like? In this case, it's a little strange because as I'm understanding it, it's sort of it would be the failure to have a provision to require compliance with and passage of Form F-31. And so normally it would be, provision such and such of, ECMC rules, such and such, subsection such and such, is what's included as being invalidated. And in here, that doesn't exist. So I'm not exactly sure what that looks like or what that means, if that means it'd be more comprehensive or how that would play out. That's really just a further reflection on that conversation that we were having earlier. I don't know if that makes this more risky or less risky. And I don't know where I am on whether to roll the dice or whether to try to play it safe. Yeah.
I mean, could we put in the SBP just that point that, we contemplated this and right now it looks like it's 4 of the 5 commissioners are ready to roll the dice and not reference F-31 because that's absurd and it's not relevant. And like inform LLS ahead of time. We understand that we may end up in the rule review, but we think it's the right place to be. And if you're going to do the rule review, we would ask that you invalidate section such and such or whatever. I don't know. I'm just trying to create a record that is very honest with what your testimony was, Commissioner Oath, which is everyone in this room is trying to follow the legislative intent.
Yeah.
AG Davenport, I know we're going against your advice, but what about that supposal? Suppose we just admittedly say it in the SBP. It'll make your AAG review lawyer's job easier.
Well, so I appreciate the question. I think, we can certainly put anything into the SBP that we want to in regard to the purpose of adopting the rule. Um, I I'm not aware of any formal process that allows us to sort of talk directly to OLLS about this. I mean, the documents that they review are the documents that they review are rulemaking documents, the rules, the AG opinion. And I also can't predict as to whether or not anyone will necessarily read an SBP.
Yeah, I guess what I'm thinking is when I have to drag my ass up to the legislature and defend what we did, I'll have the SBP in my back pocket and we can tell them, look, we were just trying to follow the legislative intent. And we decided that the better way to go is this way.
I would probably recommend that the SBP, if it doesn't already, and Deputy Director Mercer-Gelman, please correct me if it does. If it doesn't already, or at least make a stronger point that one of the biggest reasons that the commission chose to adopt the test that it did is in furtherance of protection of public health, safety, welfare, the environment, and wildlife resources, and that the inapplicable F-31 test would not advance that goal if that was a requirement in our regulations.
AG or Deputy Director Mercer-Gelman, I think we've got some language in there, right?
We do. I think Mr. Davenport's suggestion could further strengthen it, so I am taking notes.
Great. All right. Well, not to beat this horse to death. I think I've heard from four that not referencing F-31, beefing up the SBP with some of the absurdity language, despite the fact this may or may not be rising to the level of total absurdity, and bringing in the intent language is where we'd like to be. Commissioner Messner,
I would throw out just I would agree. I'm not sure that this rises to the level of absurdity, and so I'm gonna go with Commissioner Ackerman on that. So I would like to not see the absurdity argument be in there. I think the enhanced protections for public health, safety, welfare, the environment, wildlife resources, the most applicable tests based on consultation with the pipe fitters union. I mean, these are all very compelling arguments. I'm not sure the absurdity piece. Um, I guess I'm not sure that it's applicable anymore, particularly because I just Googled, F-31 and found a number of references to welding. And so I'm not sure that it is absurd, but I think that we have better protective standards in place that take the place of that. So,
all right, I'm fine with that. I did appreciate, I mean, I think it is absurd, frankly, to reference something that where we know there's two other exams that are protective. And I agree, Commissioner Ackerman, with your thoughts about Mr. Martin's thoughts that referencing it could do more harmful things. But if we don't want to reference that, that's fine. Let's just give direction to staff to beef up the SBP as best we can with the relevant pieces, like you just mentioned, Commissioner Messner. I think that's helpful. And with that, Commissioner Oath, are you more comfortable one way or another with regard to dice throwing?
Yeah, I mean, to be clear, I don't certainly don't oppose that that approach. So yes, I am in agreement.
Okay, so all five commissioners are in agreement that we will thank you for the creativity, Mr. Davenport, but we're gonna not reference F-31, and we will beef up the SBP as best we can, and we'll be ready to defend this discussion before Legislative Legal Services if that becomes necessary. All right. I believe we've addressed that part of the discussion. Does any commissioner have thoughts, deliberations on the rest of the staff's red line? Commissioner Messner?
Thanks. Two things. I think staff asked us a question whether we wanted to see it delayed, and whether we wanted to have the exemption in there for existing welders. I'm okay with the implementation being delayed to the date that's indicated in the red line rules. I'm not okay with the exemption because I do think that the opportunities to be able to meet that 7,000 hours that we've developed in the rules provide plenty of ways that an existing welder in the oil and gas field can meet that 7,000 hour obligation. And so I think that exemption for existing workers, particularly with the knowledge that this was a known thing since 2019, I would be a no on the exemption, but a yes on the delayed implementation.
Just so I'm keeping my notes correct, Commissioner Messner, the yes on beginning July 1, 2026, operators are unsure, and then it flows into all the various ways to get into compliance. You're good with that, and you don't want to see the exemption, which is referenced at paragraph 5. So we would delete paragraph 5 and renumber 6 and 7, 5 and 6, I believe.
Yes.
All right. I'm comfortable with that approach. I think that giving them to July 1 of 2026 is a good idea because it gives everybody a chance to get their ducks in a row. Go back and find their hours or whatever else they're going to do, and it's not going to be effective like, October 10th or whatever it is otherwise. Others with thoughts on those two comments? Anyone in a disagreement? Commissioner Ackerman.
Thanks. I'm not in disagreement. I just want to add a little bit to what Commissioner Messner said because I was going to raise the 602B5 issue as well. I think it probably doesn't directly comply with statute. And so I'm in agreement with Commissioner Messner on taking it out. I, I don't think it complies with the plain language of the statute, but I also don't think it complies with the intent to ensure technical proficiency that I believe was intended by the legislature. And I do think the way that our staff has crafted the rules creates significant flexibility in a way that does comply with the statute, that would make this doable and would comply with statute. I particularly think that provision that includes or supervised by a person with 7,000 hours is a key mitigating factor, meaning that there would need to be one 7,000 hour person on staff, and otherwise others can be supervised by him or her. I think that does provide sufficient flexibility, and I would also be in favor of removing that. I also wanted to clarify that I don't have any objection to the statement of basis and purpose modifications that were raised by Ms. Ryan. I have those written down. I think just two of them, the if any statement, basis and purpose addition, I have no objection. And then the or individuals addition to the compliance officer, I have no objection.
The other one she had, Commissioner Ackerman, was deleting the word bachelor degree and just using welding programs. Do you want to comment on that one?
Um, I didn't have that one written down, Mr. Chair. I'm not sure that I'm prepared to comment on that without a little bit of thought.
Commissioner Cross, you were nodding that you were remember that one. Do you want to weigh in on that?
I'm fine removing the bachelor's degree aspect of it, for the simple fact that some of this could happen with an associate's degree. It could happen through a lot of different ways. And so I think specifying a bachelor's degree is not necessary.
Okay, so wait, comma, if any, is in unless, or let me just summarize. We're contemplating wait, comma, if any. We're contemplating or individuals, not just in the singular individual, and then deletion of the word bachelor so that it says welding programs. Does anyone have concerns or heartburn with any of those three proposed references?
I just need to better understand that one because, and I'm trying to rush to find it now. So give me just a second. But so 602B4B does talk about associate's degrees, bachelor's degrees, other vocational opportunities to get 2,080 hours, and this other provision for being able to have operations. That's all pretty broad, but where in the statement of basis and purpose is just bachelor degree referenced? I'm not finding it right now.
Page 7.
So
Or page 9 of the red line version, bottom of the first paragraph.
Says it's the commission's understanding that welding bachelor's degree programs include significant practical experience. And I just, given that, as you said, associate's degrees and other programs provide those opportunities, I think it's.
So that it's all right. So it doesn't, that's fine.
I think so too.
Yeah.
Does our staff or the AAGs want to weigh in on this last point?
Mr. Chair, if I may, staff does not oppose the revision suggested by Ms. Ryan. The reason that that sentence focuses on bachelor degrees is because that's the only educational attainment level that can satisfy the entire 7,000 hour requirement. So staff was trying to make the point that that still satisfies SB 181's requirement for quote on the job training, because those kinds of programs include on the job training. We didn't feel it necessary to specify it for the other levels of degrees because those can't encompass the whole 7,000 hours. So they'd have to be combined with some other experience. But to Ms. Ryan's point, it's true that all of these programs require the experiential component. So staff has no objection to that change.
All right. Does any commissioner object to these three language changes that we've discussed? All right. So we've gotten through that. Others with comments on staff's red line or anything else for the good of the cause? Commissioner Cross?
Thank you, Mr. Chair. I just want to make sure as I was looking through the red line, the very end of it as it goes into the numbering and formatting, I just want to make sure that that's cleaned up. And I can bring up the specific part of it. Oh, way up to the right one. So at the red line of the rules, page 13, for example, we talked about removing sub point 5, and then it has 6, and then 3, and then 7. And also in the last part, it says, upon request from the director, the operator will supply the director. And I think too much might have been deleted there. It says, and certification records. And I think it should still say supply the director training and certification records. So just want to nits, but want to make sure that that's taken into account.
Thank you, Commissioner Cross. That's what happens when staff is editing on a tight deadline. We will make sure to fix those portions.
No concerns here.
All right. Any further deliberative thoughts? Commissioner Ackerman?
Thanks. I just wanted to address, I believe Ms. Ryan raised the issue of making sure that we specify what standards needed to be used at the time of application. If I understand her comment there correctly, I believe that the APA probably does that for us already. I think we would just muddy the waters, including other clarifying language on that front. It's clear that the regulations in place at the time of an application are what are applicable.
Yeah, I believe that is clear within the Administrative Procedures Act. AG Davenport, do you agree with that? Do you think we need further additional language on that front?
I agree with that. I think the APA is clear on that front. And I would just note that unless the commission decides otherwise.
Okay.
You know,
all right.
Yeah.
Looking around for final deliberative thoughts. All right. AG Davenport, quick question for you. We've talked about the various elements of things we want in, things we don't want in. We've given direction to staff that we want the SBP to not reference the absurdity case, but to do a better job of referencing the good stuff that we have in favor of our finding. Do we need to do anything more? Do we need to give staff time to rewrite, or can we just make a motion? You're still muted.
Thank you. My computer's being so slow today, it won't even recognize the button. Anyway, I apologize. Well, I think you can do a couple of things. You could make a motion to direct staff to conform the rules and the SBP to the deliberations today, and authorize staff to simply finalize the SBP and the rules without further commission review. That is something the commission has done in the past. In other words, this would be the last time that you, as a commission in open session, would see those rules before they're filed with the Secretary of State and the SBP, for that matter. You could also, but if you take that tact, I'd recommend kind of a summary discussion to make sure that everyone is clear on, from the things that staff released yesterday, what exactly is changing, and certainly that AAG Rollins and Deputy Director Mercer-Gelman are clear on it as well. You can also direct staff to go back, make changes to the SBP, and come back again in open session to review all of that word for word, or have an opportunity to review it for word one last chance.
All right. I'm sort of in favor of the former, not the latter, but I'm only one vote. What do other folks think? So we'll roll through the list one last time and then just motion to approve accordingly kind of approach. Who's got the list? Looking at you, Miss Mercer-Gelman.
I have a list and would appreciate the commission's input if anything's missing. So going in the order of what was discussed here, first is to revise the SBP with respect to 602B4 B4. That was the equivalency for oil and gas work in oil and gas related positions. The direction to revise the SVP to make it clear that that's limited to operations, not administrative or other roles. Next is the subject of the F-31 exam. My understanding is that we will leave the draft rules on that point as they are, so not incorporate the F-31 and beef up, to use one of your expressions, the SBP to discuss not the absurdity doctrine, but discuss the fact that the commission has chosen appropriate tests to further the legislative intent, specifically to ensure protection of public health, safety, welfare, the environment, and wildlife resources, and that the inapplicable F-31 exam would not serve that purpose. So really just expanding that point to focus on legislative intent in the commission's decision not to include the F-31. As with respect to the two items that staff felt were open questions, we are instructed to keep the language delaying the effective date of the welder requirements to July 1st, 2026. And we are going to delete the exemption that is currently in 602B5 for existing welders. We are going to make the modifications to the statement of basis and purpose in Koga's red line, adding the if any language around the weight to give previous violations. For compliance officers, we'll specify individual or individuals, and we'll remove the reference to bachelor's degrees that's in that red line. Then we are going to fix our formatting issues and fix the language regarding training and certification records in 602B7. That's my list. I would appreciate if any commissioners or Mr. Davenport have anything to add. And I'm also shouting out to my internal team to make sure they didn't flag
Why don't we
anything.
do this? Let's take 5 and give all the teammates a chance to take a look at their notes. Let's return at 2:50, and then we'll make sure we've got everything right.
Thank you.
Mr. Gilman, did you guys have anything further outstanding?
Nothing further from me. Thank you.
I don't believe so, Chair. Nothing further.
All right. Does anyone care to make a motion?
Sorry, Mr. Chair. May I interrupt? And I
Yeah,
apologize.
absolutely.
I lost the Zoom for a minute and had to get back, so I missed the first couple of minutes. May I suggest a motion?
Actually, that's a really good idea.
Okay, thank you. Well, the motion that I would suggest is approval of the draft rules and SBP dated September 2nd, 2025, as modified by the deliberations here today. And I don't think we have to go through them in the motion. They were discussed right before we went on a quick break, but as modified in the deliberations here today, and also to include in that motion authorization to staff to make any conforming changes, fix typos, fix any minor issues in the rules or SBP without that don't change the substantive provisions of either without having to come back to the commission for authority to do that.
So
Great.
moved.
Second. Motion and a second. Is there further discussion? I think the 5 commissioners want to send out a hearty thanks to our staff, in particular for the quick turnaround over the Labor Day weekend. And I also want to thank our stakeholders. I think the involvement of our stakeholders made the statutory alignment rulemaking and the rules promulgated therein better, and that's what we're aiming for. With that, I would call for a vote. All those in favor signify by saying. Oh,
go ahead. No, I just want to also acknowledge that by ending this rulemaking hearing also closes the record on it.
Correct. Do we need to move that?
Could we consider it included in the motion, mover and seconder? Is that all right?
Yes.
Okay.
And yes. All right. Anything further? All those in favor signify by saying aye. Aye.
Aye.
Any opposed? The motion passes unanimously. Thank you, everyone, for the good work. That concludes the agenda for today. I note that we do not have a meeting next week due to various absences of commissioners, so we'll see everybody on the 17th.